The question is there anything you would mind getting over to?
All right, now that we finally have a quorum, we're going to get started here. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 21st, 2024. We have 15 bills on the docket. We're going to start off, the Senate President is here, so we're going to start off with Senate Bill 774 with the Senate President. Welcome.
Thank you, Mr. Chairman. Had the panel join Sheriff Sam Cogan, Howard County Sheriff's Office Colonel Mark Verderheim, yes, Colonel, thank you. Brant Fisher, who is the president of the Brewer Hill president of Brewer Hill's neighbor and the Southeast Baltimore Police Community Relations Council, and then Brad O'Brien is the Federal Hill Neighborhood Association Public Safety Chair. Thank you, Mr. Chairman and members of the Judicial Proceedings Committee. It's my honor to present Senate Bill 774, which is a concept actually that we have discussed in this committee previously. And the derivation of it goes back to a visit to New Orleans and the French Quarter in probably about 7 or 8 years ago, where I first learned of a separate approach that happens in Louisiana and in New Orleans in particular for specifically the French Quarter, where as those of you who have had the pleasure of participating or seeing Mardi Gras or the French Quarter ever, it is a very different location. It is a high concentration of alcohol establishments, a lot of live entertainment. It is something that is akin to areas that we have across the state at certain times of the year. And what I learned at that time was that in New Orleans and in the French Quarter, there was a separate program that was meant and built to relieve the pressure of the local New Orleans Police Department with a targeted approach for an entertainment district area that allowed for a very thoughtful and I think largely appreciated approach to the entertainment district in New Orleans. It was actually our former commissioner who was one of the architects of that program, and it used state police officers from Louisiana who voluntarily chose to participate in this extra coverage for the entertainment districts under certain areas. They had a lot of interesting components where they were put up in hotels. That's not part of this piece of legislation, but they had different ways of incentivizing additional coverage to supplement the local coverage that comes from the New Orleans Police Department. And so this is a concept we have been considering and thinking about and trying to work on over the years. What this piece of legislation does is establish a district, an entertainment district, based on the concentration of alcohol establishments and live entertainment, to have a fund that would be administered through GOCAP, but then would have a local program manager who would oversee and operate the additional coverage and security for highly trafficked areas across the state. So you can think in Federal Hill, in Fells Point, in Ocean City, in Frederick City. There are certain times of the year when certain events or certain parts of the geographies of our counties have a heightened need or a heightened exposure and need additional coverage. And so while in many cases, local jurisdictions have tried to do their best, there is certainly a need for targeted investments to make sure that when people are enjoying themselves in the city of Baltimore, in the state of Maryland, that they can feel safe. And you will see that I'm joined today by the sheriff from Howard County, and that is because of a horrific incident, which I'll let others describe, that happened in our district this year, which was when off-duty Howard County Sheriff Deputy Ryan Demby was enjoying himself with his friends in Federal Hill. It was one of these nights where things were slightly out of control. There was over consumption by lots of folks. It was one of the evenings late at night. Tempers were high. Somebody went and found a gun from, unclear whether or not it was their home or their car, and shot and killed the sheriff's deputy who was there, not on duty, was there in an informal capacity. And it is the worst case of possible scenario of what can happen in the combination of crowds that get out of control, the addition of firearms, and a general sense of chaos not being managed. And so this was a horrible, horrible situation. And what you have before you is a piece of legislation that's trying to create a structure that we can prevent something like that from ever happening again, not just in the city of Baltimore, but across the state of Maryland. And so I'm so thankful to my sheriff for being here as well, Sheriff Cogan, who has been really a breath of fresh air and energy and bringing new ideas, and has been a thought partner with my two community leaders in the 46th district, who have been really galvanizing the community around new ideas for how we can make sure that we want more people coming to the city, to our high entertainment areas across the state, but we also want to make sure that they're safe. And that is absolutely critical. So with that, would urge a favorable report and would hand it over to members of the panel. Yep.
I'd like to thank the chair and the committee for allowing me to testify. My name is Sheriff Sam Cogan. I am the sheriff of Baltimore City. And before that, I was the neighborhood association president right by the Federal Hill area in South Baltimore. And I helped with these guys work on this program, which has been a while in the inception. And one of the things that we see in Baltimore City, and you see this in other places as the Senate president, I also want to thank you, Senate President, for doing this. One of the things that we see is on like when you have an Orioles game or a football game, or it's a holiday weekend, the crowds swell in these areas to the tens of thousands. And when you see those, and when you see this on Thursday night, Friday night, Saturday night, you'll see the crimes of opportunity go up. And so these are robberies, these are carjackings, these are assaults, and they occur as the night goes later. And so I have a very good working relationship with the police department and the police commissioner. I've talked to Commissioner Worley in Baltimore City, and when he asked for my help, he asked me, can you help in Federal Hill? Can you help in Fells Point? Can you help supplement my officers? Because I don't have enough of them. I have a shortage of them. Can you go in there on an overtime basis? And can you go in there when courts are closed and use your law enforcement personnel to try to shore up these areas so that people can, from all around the state and all around the city and really all around the country, can use these areas safely? And in order to do that, when you have an area like Fells Point or Federal Hill where you have 50, 60 bars in one area, you really do need a significant law enforcement presence to do that, to prevent these crimes of opportunity, which again are carjackings, armed robberies. And we had the horrible event with the Howard County Sheriff's deputy who was killed, which is illustrative. But I'm sure that my community association leaders here are going to talk about what they see and what happens in their neighborhoods, because these are also residential areas and they impact the residents that live there as well. So I'm very much in support of this bill. My office stands ready to assist, to try to help if there's a funding mechanism that I could bring my sheriff's deputies out. A lot of them are working part-time jobs, and this would be a much better way for them to utilize their law enforcement to help the community. So I'd love to do that, and I'd urge a favorable support. I could take any questions too.
Good afternoon. Thank you to the committee chairman. My name is Mark Verderame. I'm a colonel of the Howard County Sheriff's Office. I'm here on behalf of Sheriff Harris, who unfortunately had another commitment, couldn't want to be here for this important issue. However, he is in favor of this bill. I won't waste your time. Sheriff Harris will echo exactly what the sheriff from Baltimore City said about having to make details to make our community safer with these entertainment areas in which we need more additional personnel. He believes that this bill provides an added level of security. More importantly, peace of mind to citizens who participate in these type of community events that are being held. Spoke briefly about Deputy Demby. Deputy Demby was a 22-year-old young person. He attended the Orioles game with a bunch of friends. Just so happened the Orioles won the title that evening. So he is with other people in the stadium, fans who attended the game. They retired to Baltimore City to experience the celebration, also the nightlife that Baltimore City can provide. Shortly after 11:30, altercation occurred. Ryan attempted to break up a fight. He was shot and killed. Sheriff Harris believes this bill will help fund the deployment of resources to communities where events are being held And if so, will deter, prevent, provide a safer environment for all. And that's why Sheriff Harris is in favor of this bill. Thank you. Any questions, I'd be happy to answer.
Thank you very much. We'll take questions at the end of the panel.
Dear Mr. Chairman and members of the committee, my name is Brant Fisher and I'm here today in support of Senate Bill 774. For the past 17 years, my family and I resided in Southeast Baltimore. Over the last 7 years, I've served as president of Brewers Hill Neighbors Association, and the past 4 as the Southeast Community Relations Council. That's partners with the police department, where a lot of that focus is coordinating public safety efforts throughout my district. Our community is home to entertainment district situated within the residential area. This district boasts several businesses that cater to residents and visitors alike, offering drinks, entertainment, and special events. Just located blocks away from the harbor waterfront for our community that attracts a lot of visitors from the city, state, and beyond. During special events, ensuring public safety has become a top priority as the population swells within attendees. Surrounding communities have diligently pursued grant funding to enhance safety measures, including security cameras, traffic calming measures, and cafe lighting, which has significantly improved safety in and around our entertainment districts. Despite our volunteer efforts, we still need additional assistance and resources. I believe that SB 774 will help establish a connection between unique entertainment districts like ours, Canton, Fed Hill, Downtown Harbor, and much needed resources. By supporting this legislation, you will help communities such as ours better ensure safety. Residents, business owners, and employees and visitors will come to our city and to entertain sports activities, concerts, festivals, and tourism. For these reasons and more, I specifically request a favorable report on SB 774. Thank you for your time and consideration.
Thank you, Mr. Chairman and members of the committee. For the record, my name is Brad O'Brien. I'm here to speak in support of Senate Bill 774. For the past 11 years, my family has called South Baltimore our home. It was a violent crime that led me to get engaged as a community volunteer. A mother walking home from the grocery store was pistol whipped while carrying her newborn baby on her body. I began to serve because I could envision my wife and my children victims of senseless crimes like that incident. The entertainment district in our community is uniquely positioned between 4 residential communities. Our district has one of the highest density of liquor licenses within the entire state of Maryland. This means that an overwhelming number of businesses in our community are open late, providing drinks and entertainment for people all over the city, the state, and out-of-state visitors as well. Our community sits within blocks of M&T Stadium, Camden Yards, CFG Bank Arena, and the Inner Harbor. That makes our community one of the state's most visited entertainment districts. However, we're simply unable to meet the needs for public safety resources based on what's currently available. Public data of 911 calls for service clearly outlines that our entertainment district is an area of need. Additionally, we can track those calls to show and identify the specific days and windows of time that have the greatest need. To increase public safety, I've coordinated a group of volunteers. We've secured over $500,000 in grant funding over the past 2 years. With that funding, we have installed fixed license plate reader cameras in areas of our community. We've enhanced pedestrian cyclist safety, traffic calming, installed cafe lighting, and additionally, we've installed cameras on private buildings to help with evidence collection following a crime. Even with those substantial efforts done all by volunteers, we find ourselves unable to properly establish a baseline for public safety in this unique district. I believe that Senate Bill 744 will help create a connection between our entertainment district and in resources that we need from the state. By supporting this legislation, you'll help communities like ours be better equipped to provide safety for families like mine, business owners, employees, and guests who come to enjoy sporting activities, concerts, conventions, or simply as tourists to enjoy what our city and state has to offer. For those reasons and many more, I ask for a favorable report on SB 774.
Thank you very much, Mr. President. To the panelists, questions from the committee? Oh, Senator Carter.
Thank you so much, Mr. Chair. It sounds like a really good idea. I think in Baltimore City, Mr. President or whoever, oh, there you are, Mr. President, we have a limited number of already established entertainment districts. You might have already hit on this, so I apologize if I'm repeating it. So this would already apply to those, I think, 4 that we have, correct?
Well, it would be determined through GoCap would have to just come up with the specific criteria of the concentration of alcohol establishments or live entertainment venues. And so it could be flexible based on certain areas. The key is that there would be some level of predictability. One of the challenges I think we have in the city is that often we'll have an incident and then there'll be a flood the zone of police officers for the next 3 weeks. And then that is not sustainable and pulling resources off from other parts of the city. And so it kind of goes back. And so then another incident happens and it's a new flooded zone. The idea here is to have areas where we know this happens over and over again, having a predictable source of funding and coverage so that it is not as expensive and frankly impactful to other parts of the city when these things happen or parts of the state.
Thank you. That's it. I just wanted to see if it was already designated for areas that we already have established or if it could be expanded.
It would be it would be up to GoCap to determine the criteria of what would be an entertainment district.
Thank you very much.
Thank you.
Further questions from the committee? All right. Seeing none, thank you very
Thank
much.
you all.
Thank you, Mr. President.
Have a
Thank
wonderful
you.
afternoon.
Thanks. All right, that'll conclude the hearing for Senate Bill 774. We'll now move on to Senate Bill 687. It's Ms. Faulkner here. Yeah, welcome.
Thank you very much. Good afternoon. My name is Nancy Faulkner. I'm the Deputy State Court Administrator. And during the time period that the 7th Judicial Circuit voted to rescind the bail bond system that was in place, I was serving as the Court Administrator at the Circuit Court for Prince George's County. First, I wanted to thank you for the opportunity to speak today. And I am here today on behalf of the judiciary regarding Senate Bill 687. The bill is a technical bill which seeks to update the criminal procedure article to comport with the bail bonds practices that are currently in place in the 7th Judicial Circuit, which includes Calvert, Charles, Prince George's, and St. Mary's counties. Both the Maryland rules and the 7th Circuit's local rules have already been updated to reflect the current practices, and I am requesting a favorable report on Senate Bill 687. I thank you for your time, and may I answer any questions?
Thank you very much. Questions from the committee?
Thank you.
All right, thank you. All right, so that, all right, that'll conclude the hearing for Senate Bill 687. We're going to move down to Senator Carter with Senate Bill 621.
Good afternoon, committee. I'm gonna bring up Dana Moore, the Director of our Civil Rights and Equity Office. And I thought that there was a witness here from ACLU of Maryland, but if not, I'm happy to begin. So most of you were here, some of you were not, in a couple of years ago when we grappled with police reform. But one of the themes that we continued to discuss and that we created enabling legislation to ensure that there would be police accountability boards throughout the state of Maryland. And in Baltimore City, we had a unique situation to some extent because we had something called a civilian review board. And while the civilian review board, it was argued for many, many years, did not have enough teeth to be effective, one of the things the civilian review board had was subpoena power. And so all this bill does is to establish that police accountability boards throughout the state of Maryland would be able to have those powers. I have some written testimony that I want to go through because I think it's important to maybe share some of the reason that we need this and some of the history, but that's essentially what we want to do. You know, we had a lot of discussions, and it's those of you that were here know, and those of you that were not here know that fundamentally we have to establish that no matter what reforms we put in place, whatever changes we make to policing, without giving the people of a jurisdiction the power to determine the policing of their district and make those decisions, I think that we fail. We cannot leave the process completely internally within police departments. We have to give the people of the community the power to make some decisions and oversight of the policing. So Senate Bill 621 will authorize a local governing body of a county, including Baltimore City, to authorize local police accountability board to exercise investigative and subpoena powers and conduct investigations of police conduct currently with a law enforcement agency investigation, concurrently with the law enforcement investigation that was already done in Baltimore with the Civilian Review Board. And so that's something that is absolutely possible, and it was actually necessary. The bill was brought before this committee last year. It did not pass. In 2021, this body, recognizing the need and the benefits of a police accountability board, did pass HB 670, also known as the Maryland Police Accountability Act. The Maryland Police Accountability Act, among other things, mandated the formation of these police accountability boards. Of course, but without having these kinds of investigative and subpoena powers, those boards are relatively impotent. And so it's important that we give them this power. It's just a next progressive step to ensuring effectiveness. I think that I'm going to let you hear from the witnesses and be happy to answer questions. I have extensive written testimony that I'm not going to go through, but I do believe this is not some exotic concept and how do we do it and what's the point of it? The point of it is to ensure that people have the power, that investigations are not exclusively internal inside police departments, to ensure that there's the transparency and the accountability that we always wanted when we made the reforms and the changes that we did. Thank you very much. Next, I'm going to bring up Dana. Oh, I was going to bring. Oh, am I limited to 2 witnesses? I think that's the issue.
I think
So
that's right. You are.
there was a city issue. I was specifically asked about Dana Peterson Moore. I want to make sure that she can testify. So.
Okay, so you have 2 witnesses. You're the sponsor. You get to choose.
So I'm going to bring up.
Sure.
It might be out of order, but I gotta deal with what I got. And she came all the way here from Baltimore, but she's important because she oversees these police accountability boards. So come on up.
Welcome.
And then we'll go with.
Sure.
One to go.
Of course.
Thank you. I'm Dana Peterson Moore. I'm a bunch of hats, the city's chief equity officer, director of the Office of Equity and Civil Rights, and also the director of Baltimore City's Police Accountability Board. We have been doing the work of police accountability and oversight for many years through the Civilian Review Board. Since this body and the state enacted the police accountability boards, we have taken the last year, a few months, to stand up the police accountability board, to do its work, to stand up the administrative charging committee. And what I hear constantly is that the police accountability board would like the ability to do concurrent investigations. In other words, they would like to be able to do their investigations at the same time as the police authority over which they have oversight. And there are a lot of reasons why that's important, but the most important reason is that you have the access, they would have access to fresh evidence, to have it immediately without having to go through the Public Information Act process, and to simply make the request. What I've been practicing law for a little bit longer than Senator Carter, not a whole lot longer, but what I have found is just the very presence of a subpoena and a respondent knowing that there is subpoena power. It allows processes to flow swifter. It allows for less controversy over what documents can be provided. We've got real-time evidence of how this works. We can look at the effectiveness of the Civilian Review Board, but the police accountability boards really across the state need to have the same ability to go in, to do the investigation, to make their assessments, to make their independent assessments. And this really is what the public wants. It's what the public needs. And this gives the much more heft and credibility to the work of the police accountability boards. Open for questions, if any.
Thanks. We're gonna I see some folks have questions, but we'll take questions at the end of the panel. We'll take questions at the end of the panel.
Okay, thank you.
Excellent. Thank you very much.
Good afternoon, ladies and gentlemen. Allow me to introduce myself. My name is Sonia Zollicoffer, and I'm in support of the bill SB 621. I am a Prince George's County retired police lieutenant. For speaking up against wrongdoing, I was demoted to corporal before my peers. Despite this, thanks to hard-fought battle, I exited the police department with my lieutenant's compensation and retirement benefits. During my 20-year career as a police officer, I served as a lieutenant, a police spokeswoman for the department, a detective, an investigator in the Internal Affairs Division. When I first decided to become a police officer, my goal was to be a detective. I exceeded those expectations. However, I never imagined that I would have to fight and protect myself along with the citizens from the same police officers who took the same oath as I did. I was a victim of sexual assault, and to be classified as a victim, there must be a perpetrator. My perpetrator was my field training officer. Throughout my career, I was punished for speaking up against wrongdoings of the department, and this continued even in internal affairs. As an investigator in internal affairs, my assignment was to police the police. I investigated citizens' complaints against officers. Sometimes there were multiple complaints against the same officer. Different complaints, citizens, same as you, would file similar complaints against officers for use of force, unnecessary force, excessive force, and racial profiling. Unfortunately, there were multiple offenses of officers not having their in-car microphones operational. This made investigations more difficult, deliberately so. I call these repeat offenders. How could I truly investigate our own police officers being charged when I face opposition for charging them? I was asked a few times not to charge officers, just to give them a slap on the wrist. I'm not against or anti-police. I am the police. We
Ma'am,
have great police
ma'am, if you could
officers
briefly
in the
conclude.
department.
The time's expired, but if you could just briefly conclude.
You have the power to change the arrogance of the police narrative of you can't come in our house and tell us police what to do. As a citizen of this county that pays her taxes,
Thank
I
you.
have the right to speak up for change.
Thank you very much. She'll have a question. Thank you very much for taking the time to testify today. Well, we have some questions and you perhaps will be able to expound upon your remarks. Senator Folden and Senator West.
Thank you, Mr. Chairman. Whoever wants to answer them, Senator, thanks for bringing the bill.
I'll take it and I'll defer to my experts if necessary.
Okay. So I guess I have a couple questions. So when we're talking about the police accountability boards, investigations, so it doesn't just deal with subpoena powers. It is the investigative authority. In addition to that, is what you're asking for. And it doesn't specify any type of misconduct that would be allowable. It just is any misconduct. So it could be from something that would be otherwise in summary punishment by a counseling statement, or it could be something all the way up to the use of deadly force. So it's a very broad application that concerns me. And I guess my question is, is there a reason that we need this that you're seeing? Or is the exhaustive investigative file that's compiled by the state's attorney, the FOPs, the other allied agencies, DOJ, if they come in, is that not good enough to be able to apply here?
So I'm not sure. I'll try to, if I understand the question. When you ask why, I can speak from my own experience and Dana Peterson Moore's current experience. We had a civilian review board prior to the passage of this new law, and that civilian review board had investigative powers and some subpoena power. We will be ending that civilian review board, and so that what will be left for the citizens will be the police accountability board. Why was it important for the civilian review board to have that concurrent power? Well, in my experience, when I was overseeing it, there were a multitude of cases where the civilian review board had findings that differed from the internal investigation process. what the internal investigation found. And so that's important as a real step, where an outside independent look at the conduct can be helpful. And so it's just about accountability and transparency and giving the people more power. Now, the Civilian Review Board was limited to 5 different types of investigation, but that was very limiting, especially when they relied in large part on how the officers were charged. And if the officers were mischarged or undercharged, or then they often didn't even receive the file to investigate. So I think the rationale for having no limitation on the types of misconduct is so that they can determine it for themselves.
Well, and I think that kind of leads me to my question, is because this law, if passed, would create a lot of untrained mindsets in the realm of law enforcement and what is legal application and what is a feeling of legal application versus illegal application and a feeling of illegal application, because the rule of law is very clear. And when we start getting into a lot of these decisions, like Tennessee v. Garner, this is a cornerstone of law enforcement that they need to know and exercise within the scope of that decision. Well, we're going to have people who are civilian reviews, have no training in law enforcement, have no idea what the rules of engagement are or use of force matrix or whatever it is, the application of that, because they've never been trained. And the thing that I find ironic about this is that currently in the state of Maryland, the only professional occupation in the state, unless you can think of one, that has a review board that is comprised of people not of their peers in the same field. Every other review board, medical review boards, the judiciary review boards, they're all people of the same professional pedigree. Is that not correct?
They are usually, but I can actually tell you, there are lawyers that complain that
No,
even
they are. They're
No, they are.
attorneys. They're
But-
barred
but-
attorneys.
if-
And this is, law enforcement has been cut out now in a separate frame.
Let's make sure. Did you want to, I want to make,
Oh, sorry.
did you want to respond to that?
No, I understand.
Okay.
And I don't think, and not that it would have made any difference at all, but I don't think that you were here when we went through all of those lengthy and comprehensive discussions about the need for police reform in Maryland and all of the many abuses that had taken place within certain departments over many years. And these abuses were committed against the people. And so one of the rationales was that one of the issues was, the problems is that the internal review process inside police departments was not resulting in accountability, and there was no transparency. So we needed to expand the ability for civilians to oversee. But I can tell you that there is training that happens with these police accountability boards. In addition to that, they have a cross-section of the community. And when I was actually on the Civilian Review Board, we had retired law enforcement officers as part of it that really did have expertise. So it's not, but let me finish. The issue is not whether they have specific police training or whether they have specific legal training. This is about citizens having a right to determine, is this the type of policing, is this the type of conduct that we want in our locality? That's what this is about. This does not take the place of an administrative charging committee at all. It's another step. It's another layer of potential oversight.
Well, okay, I understand that. So I guess, again, my question is there any other oversight board that provides these type of subpoena or investigative powers anywhere in law for any other profession in the state of Maryland?
So I don't know, but I don't think that, I think that policing is absolutely a unique profession because it is the only profession where those members of that profession have a license to use force and carry a gun, and sometimes it results in harm to people, even death. So that's why it's different.
Yeah, and there are policies in place. There are measures already in place. So, and I guess the next thing is that on this investigative, you're saying that they have training. There's no investigative training. They're not getting specialized training. So what we're creating is a subjective opportunity for people in a field that they have no training of, of different uses of force, the applications of use of force and the like, other than a subjective feeling based on emotion and not the letter of the law. And that's where I have a concern with this, is because when you apply such a subjective standard to the letter of law, it creates diversion from the intent and what the law is. We're now creating a whole new element of an investigative parallel process that they're going to be subpoenaing people during an investigation that they still have the opportunity to go in front of a jury of their peers and in a trial board and or the court of law. So for this review board, the reason the review boards were put in place was after an adjudication of police misconduct or an investigation, so that the case can go forward and be reviewed by them to see if there's a concurrence on the disciplinary measures moving forward. Not to be the investigators and certainly not to be
So the
subpoena
Civilian Review
powers.
Board actually in Baltimore did have that investigative power. So it's not unique. It's not something that's never been done. But, I would argue, and not that I want to argue with you, Senator, but the same thing that you're talking about in terms of the, average citizen without the training could absolutely be said for our jury system. We expect citizens to go into a courtroom and apply the law as they are instructed it is to the facts and make a determination with no specific expertise. This is the
Correct.
same kind of concept where I believe that citizens have a right to that. They have a right to be able to oversee the policing in their area. And all of these decades where we didn't allow it really did contribute to some of the major abuses that we found.
Well, we don't allow those jurors to subpoena records, and we certainly don't allow them to go out and conduct their own investigation through a legal measure legislatively.
I'm gonna let, since she's currently overseeing the
No, it's okay. It's fine.
No,
I just
because I
said,
think
I
it's-
said
I
about
think
the
it's
jurors. I said
I
the
think it's
jurors.
important to understand that in Baltimore, this process to a large extent already happened, and it didn't result in any major horror of horrors. It did result on occasion in differences between different findings between the Civilian Review Board and the internal police process, which I think is healthy. Because you know what, even if the Civilian Review Board didn't prevail, at least it was a robust discussion where citizens didn't think, well, this is all covered up in the closet, something that we can never have any input on. And I think that's another step that's important, is to give people that sense of ability to be involved and engaged, and it helps to establish trust.
And they
which
are involved
Trust
in
is
that
still very
process.
much
That's where the ACC and the PABs come in. They are involved in that process of trust. But thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chair. So Senator Carter, you and I were here several years ago and during a hearing which I remember quite vividly about we were getting rid of the Officers' Bill of Rights and substituting the legislation which is currently in effect right now. And I can recall vividly being here that afternoon and proposing an amendment to the bill. The bill provided that the citizen complaints would be filed with the Police Accountability Board. And I moved to amend the bill to provide the citizen complaints should be filed with the police department, which has all the investigatory powers, which they've been using for years. And the amendment went down to defeat, as all amendments did that afternoon. And after the amendment was defeated, I can recall asking, so what does the Police Accountability Board do once it receives the citizen complaints? That was followed with a long silence. Then the chair of the committee turned to committee counsel and said, can you answer his question? And committee counsel also was silent for a while and finally said, well, the bill doesn't provide for anything to be done with the complaints. And I said, you see, it's very vivid in my memory. So here we are now 3 years later dealing with the same issue. So complaints are sent to the Police Accountability Board, which, as I pointed out at the time, has no staff, has no investigative staff, has no budget to do any of this stuff. And here's this bill that now is seeking to ramp up police accountability boards by hiring, I guess, staff, investigative staff. So here's my first question to you. Does the city of Baltimore or the body of any county have a right to issue subpoenas? Let's get away from Baltimore. Let's just say
The city of Baltimore or the
Frederick County.
specific entity that we're talking about?
Well, this bill says governing body of a county, including Baltimore City. So let's get away from Baltimore City. Let's take Frederick County as an example. Does the county executive of Frederick County have the power to issue subpoenas right now and require people to come before her to testify under oath?
I'm going to let someone else take the question, but I don't think that is what you're talking about is what's intended here.
Well,
I think that we're talking about a specific police accountability board.
Excuse me, this says that a local governing body of a county may by local law authorize its police accountability board to exercise investigative
See, that
subpoena
you just said it,
powers.
authorizing the police accountability board. So really quickly, and then I'm gonna I think that these others really want to say something and I'm probably missing something important, but I think it's important what you just talked about years ago, what you just characterized your interpretation of what happened. Well, my interpretation of what happened is that we wanted to create enabling language in our police reform package for the creation and building out of these police accountability boards. And some of the specifics that you're talking about, we did not have then, but that is why we're here now, because this is an effort to build it out. And we want to allow it to be as it is in Baltimore, all over the state, should the jurisdictions want to do it. And in Baltimore, we have a little bit more of a sophisticated foundation because we started with a civilian review board already. And that civilian review board and the police accountability board is not just, as the other senator said, it does have trained investigators, and it is a structure that we are hoping to improve, and not just in the city, but all over the state. But that, I'm gonna let the other side.
No,
I'd just like to quickly add that in Prince George's County, they do have subpoena powers. It's just,
Let's just, another thing is, the senator will direct the question to a witness in particular. Sure. We'll have it.
So I was actually talking to the sponsor of the bill. Could go back up there?
So I thought one of the other people had something to add. That's why I was gonna let them talk, but apparently not. So I'll just go ahead.
Okay, so yes, so I apprehended that was the ultimate intent of the bill, is to take these accountability boards, which don't have any staff or any budget to
Some
speak
of
of,
them don't.
and build them up
Yes.
into large organizations which will investigate police. So I get that. My question to you though was, does the county executive of Frederick County currently have the power to issue subpoenas and require people to come before her and under oath answer questions?
Ms. Moore would like to respond.
Senator, would you like to?
Sure.
No, because I don't really understand your point. So let someone else answer it. And I don't know what this.
So Dana Moore again, I just wanted to clarify just a couple things. The Police Accountability Board in Baltimore City and the ACC are staffed by my office. We have 17 positions that are, they are within the Office of Equity and Civil Rights, and I have the ability to designate which of those people would work on the Police Accountability Board. So we are fully staffed. For example, we're in the process of doing the annual report for the Police Accountability Board, and my office is doing a lot of the work to make that happen. There's also a budget. The budget primarily goes to paying the staff, training and education. And it's really, really important for everyone to understand that there is training for the police accountability boards and the ACC. That is done through the state of Maryland. There's a comprehensive training coming up in March. I tried to get myself onto that list and they told me no, because I'm not a member of the PAB, but it's very robust training. The other thing that is really important to understand is that many of the members, at least in the PAB in Baltimore, are lawyers. They understand procedure, they understand evidence, they understand that evidence can change, that you've got to listen to both sides. They're also represented by lawyers. The city's Office of the City Solicitor represents the Police Accountability Board.
You see, this is why I wanted to move it away from Baltimore, because I know Baltimore's had the Civilian Review Board for many years, and it's staffed, and the city taxpayers pay for it. But none of the other counties have this. And so this is not a Baltimore City bill. This is a statewide bill.
If I could just make one quick correction, what I just described for the Police Accountability Board in Baltimore is replicated across the state. Let's talk about Baltimore County. Baltimore County also has staff for its Police Accountability Board. They are represented by council. The council is through the law department or office of the county attorney, in Baltimore County. That's a young man by the name of Henry Caligari, who's doing a great job. So really, this body voted to change how police accountability happens across the whole state. But what it did not do is what we all feel is really, really important, is to provide that strong investigatory authority as well as a subpoena power. And that doesn't mean that you're going to have, at least in Baltimore, there's 17 members, or in others, it's 5, it's 7, a number of non-police persons, wildly using this authority. It simply means that the ability to do these investigations will be there. The boards don't have to wait until the police department or whatever the enforcement agency is done. It allows for quick resolution, quick reviews. It allows really, in many, many ways, it's a benefit to the officers that are at the center or the target, the focus of an investigation, because it happens in a more consolidated way. Officers who are, responding to the charges don't have to wait a year or 2 or longer to clear their record if that's the outcome.
Okay, I've let you go on for quite a while.
I appreciate it.
Could I
Thank you.
interpose a question, please?
Yes, sir.
Okay, great. So would there be any constraint on the right of these public police accountability boards to issue subpoenas? Could they issue dozens of subpoenas, hundreds of subpoenas? Would it simply be within the judgment of the members of the board as to how many subpoenas they issue?
Always, with any entity that has the subpoena power, there's always guardrails, and it's called judgment.
And would the person subpoenaed have the right to object to the subpoena and contest the subpoena?
Absolutely.
How would such an appeal or a contest be handled?
It would most likely go through the court system.
Well, this doesn't provide for that, does it? This bill doesn't. It just says issue subpoenas. There's no guardrails put on how many subpoenas the board could issue, or with respect to what, or who gets issued subpoenas, or who can contest subpoenas, or how such contests are handled. That's not provided in the bill, is it?
It's not provided in the bill, and I know others want to speak, so I'll defer. It's enabling legislation.
If a witness shows up before the Police Accountability Board, having been subpoenaed, is the witness permitted to have counsel represent it? I don't see that here in the bill either.
So I think that's because this bill is just to allow the counties to say this is what they want.
But there's no system put in place to handle the subpoenas, is there?
And then the system would be established through the legislative process for the particular county. Just as when we establish, y'all, they, us, established the police accountability boards, each county was permitted to determine how they wanted their police accountability board to be established.
So in your opinion, this bill would authorize each county to set up its own system of justice dealing with the accountability boards?
So I wouldn't say its own a system of justice, but it would allow each county to determine for itself the best way for it's that county to manage the investigation process.
Suppose someone were to defy the subpoena and refuse to come. What would be the penalty that could be visited on that person for not complying with the subpoena?
I think in the best of all worlds,
under this bill, what would be the penalty that could be imposed on someone for failing to comply with the subpoena?
So just as the question about the number of subpoenas and the scope is not answered in this bill, the penalty for defying a subpoena is not addressed in this bill. That would
Would that be
come,
up to the Police Accountability Board?
I think it would,
Could the board rule that someone who failed to comply with the subpoena must go to jail for a period of time
I think
until they complied?
that's an absurd outcome.
Why?
Because we don't do that
That's
in
what,
America.
that's what courts do when
That-
someone doesn't comply
well,
with the subpoena.
In extreme cases, but not here.
It's not
And-
absurd to allow the courts to put someone in jail for failing to comply with the subpoena.
So
Why would it be absurd not to allow the Police Accountability Board to put
So
someone in jail?
the answer to your question is that would be determined by each county when they proceed to establish their investigation and subpoena process.
Okay, so let's assume we get the subpoena process underway. And now you have parallel investigations. You have the police department conducting its investigation. You have the Police Accountability Board conducting its investigation, each, I guess, totally independently of the other. Correct?
Yes.
So the PAB would not have to coordinate with the police department, nor would the police department have to coordinate with the PAB. You'd have totally independent parallel investigations of some incident that occurred, right?
Correct.
Okay. Isn't it likely that in the process of these investigations, people are going to be asked questions which could incriminate them along the way? Isn't it possible that you're going to want to give someone immunity in order to get the proper answer to a question? How is that going to play if one of these investigations grants immunity and the other doesn't? Have you thought about the fact that the two investigations could compromise each other?
Yes.
So that at the end of the day, there could be no successful prosecution of a policeman because the investigations had been compromised along the way?
It's possible, and I think that gets addressed once the counties have the authority and the power to even establish the investigation and subpoena process.
Okay, thank you.
You're very welcome. Thank you for the questions.
Really, Senator West covered almost everything I was going to ask. In Harford County, we were just debating whether our liquor board should have subpoena power. And it was royally pushed back by citizens, lawyers, and the liquor board itself, right? Because it could be very abused and there are no guardrails. How would it be enforced? What I don't understand about this bill is, one, why it's not a local bill for Baltimore
Because police
City,
accountability boards are enabled all over the state in every jurisdiction.
or why other counties and jurisdictions were not consulted, because certainly Harford County just does not fit into the model that you all have. I
Harford
just
County
look,
doesn't have to have one. This is again enabling.
I think it's a policy issue for us to decide how much authority we are going to give each county, right? So I think it is important to ask counties how they feel about it, right? Rather than just have a bill that obviously is coming out of Baltimore City as best I can tell. Perhaps Prince George's, that's fine too. Those are two very large jurisdictions who may have a whole different system. But what I'm troubled by that it's not a Prince George's and Baltimore County bill, that no other counties were consulted. And you can tell me if you consulted other counties, if you looked into the issue of how this would work itself out, I'm all ears, but I don't feel like any of that occurred. But if you consulted Harford County or any other county, let me know
So for
what
the
that
record, I
was.
didn't consult any other county personally, but I don't tend to consult every single county on any bill that I specifically sponsor here.
You certainly
Usually
don't
it's a
have
state
to.
bill. And the
But you're
reason is
answering my question.
this is,
You're
no,
answering my question that
I'm
you're
answering the
not
question
consulting
that
other counties.
every county already has the ability to do that. That's already in the law.
what?
So there's no reason to go back and question it. It's if a county can be as expansive or in it or less or not expansive as they want to be with these police accountability boards. This is enabling to say that they can have the investigative power and the subpoena power. With regard to back to what Senator West was talking about, I can only tell you that in my experience when I was working in oversight with the Civilian Review Board, when there were contested subpoenas, there were people that took the issue to court to let a judge determine whether or not they had to respond to the subpoena or not. There were no issues about jail or not jail. These were civil and administrative proceedings. That wasn't a criminal matter, and nobody was put in jail, and no one would suggest that a board would have that authority. It's just a matter, and I'm kind of stunned by the 2024 apparent opposition to the idea of citizens of a jurisdiction being able to investigate the conduct of the officers where that police them. So
What did you mean by a local governing body in this bill?
so I don't have the bill up here with me. Does anybody have the bill, please? Or you can just read it to me. I'm sorry. See, the chairman called me
not
a
a
little
very
faster
long
than I was
bill.
ready, but I took it.
think you know it.
No, I just didn't bring it all up here with me. Thank you. So I'm sorry, you said what? A local.
It's not a
govern-
long bill. It's the.
I know
first-
it's not, but
the
where-
first sentence.
Oh, subject to paragraph, a local governing body of a county, including Baltimore City, may by local law authorize its police accountability board to exercise investigative and subpoena powers. I think it's self-explanatory.
Well, just tell me what that is. Is that the county executive? Is that the county council? What do you mean by a local governing body of the county?
It's likely going to be the council. It's likely going to be the council. I know in Baltimore City, they have a lot of input into the people that serve on the boards to make sure that they represent the whole city.
But, so we're not sure. It could be the county council, could be the county executive. Is that correct? We're not sure.
So I can tell you that the governing body is usually executive and legislative, but it could be the council. I think that the council in any jurisdiction could create the mechanism that they want. So I think that what you are attempting to do is force us to prescribe to every jurisdiction how they would handle
I'm
it.
just asking you.
But I don't
questions. Do
want
not
to prescribe to
do
every
not
jurisdiction
say
how
what
to
I'm-
handle
that
it.
I'm forcing you to do
But I
something.
don't want
take
to
umbrage with
prescribe
that.
to each jurisdiction. I don't want to prescribe to Harford County how they should handle it. It's enabling Harford County to handle it the way that they choose to handle it.
I'm trying to figure out if any research was done on this. So again, I think that's unclear. I don't know whether the bill was envisioning that the county, that a bill would be introduced, that the county would vote on, that the county executive would sign into law. And I'm asking the same thing, Senator West, just answer it later, which is how in the world the county council or the county executive could even enact a bill for subpoena power. In our county, it goes through the courts.
Yeah, you can say something if you want to.
Can I answer?
You gotta stand up.
All right, that's,
I
you
just
can
really
follow up. You can
To
follow up.
clarify, you
I'm-
mentioned that other
uh,
counties weren't
she can-
consulted. This is just enabling
Ma'am,
legislation
Ma'am,
because
ma'am, I got this one.
the locals were
Ma'am.
saying that it was
Ma'am.
preemptive.
Sorry.
I'm just trying to clarify a question. for
I
her.
understand, but I'm only enforcing the rules because they're the same for everybody. And so I just want to make sure that everyone has the same standard. Everyone's good. Thank you, Senator James. All right. Does anyone else have, Senator James, were you done? I'm sorry. Were you? Okay, yeah. Okay. Just for Baltimore City, how often did you exercise subpoena power?
So in the time that I've been with the office, we have, through the Civilian Review Board, we have exercised the subpoena power twice. We did it once in 2021. And of course, we went through the court system to actually get the subpoena and have it authorized and processed. And we are processing one now.
So you go through, so how was it enforced? Like, let's say someone just said, hey, I'm not going to do this. I'm not showing
Sure.
up. I'm not producing any documents. I'm not.
Yeah, through the court system. The circuit court for Baltimore City.
And what would be the consequence of non-compliance?
Well, I think it's already I don't know exactly because we.
So if you're in contempt of court, what happens?
Well, if you're in contempt of court, there's a range of penalties that could be imposed.
Could you list some of them?
Well, the mildest would be that a defense would be denied, a defense to the accusation. You would be precluded from asserting a defense. You would be precluded from having a witness testify. There could be a daily monetary penalty. There are.
Could you be incarcerated?
I don't think so. I don't see that happening through this process.
So the potential is you could be incarcerated, you could be fined for contempt of court.
You could be fined.
Okay.
Yes,
Thank you.
you're welcome.
Any other further questions? Okay. All right, that concludes the testimony for the proponents of the bill. Let's hear from the opposition panel. We hear from Mr. Davey is signed up.
Good afternoon. My name is Michael Davey. I'm General Counsel to the Maryland State Fraternal Order of Police, and we are requesting an unfavorable report on Senate Bill 621. As we all know, the Maryland General Assembly passed the Maryland Police Accountability Act in 2021, which began and took effect in July of 2022. The passage of SB 21 would grant the Police Accountability Board the ability to exercise investigatory and subpoena powers for complaints of misconduct or basically anything else they wanted to investigate. There's no limit in the bill. The FOP believes that the bill is not necessary as the Police Accountability Act already grants investigative authority to the Police Accountability Boards through their administrative charging committee. If the bill is passed, and I'm just going to take Baltimore City as an example, there could be up to 4 investigations on a police officer or whatever. The Baltimore Police Public Integrity Bureau would do an investigation. The Baltimore City Civilian Review Board could do an investigation. If the case involved death or serious bodily injury, the Attorney General's Independent Investigation Division could do an investigation. And this would add another layer, the Police Accountability Board. The Administrative Charging Committee, which is part of the Police Accountability Board under Public Safety Article 3104E, already has the authority to review every investigative file, review their body-worn cameras, call the officer in to appear before them, request additional information, require additional investigatory steps be taken, and in fact, issue subpoenas. The question then has to be asked is, with all these investigations, what if they all are not consistent? What if one says exonerated and one says sustained? What is the department supposed to do with that? As a defense attorney, I win. Anytime there's multiple investigations and multiple witnesses are investigated by multiple people at multiple times, there's bound to be inconsistencies. And if we're going to try to hold police officers accountable, these inconsistencies are only going to hurt the department in its attempt to hold police accountable. Based on the information that I provided, based on our concerns, the FOP requests an unfavorable report on Senate Bill 621.
Thank you very much. Questions from the committee? Seeing none, thank you very much.
Thank you, sir.
All right. With that, that'll conclude the hearing for Senate Bill 621. We'll now see Senator Benson is here. Welcome. Senator Benson is here to present Senate Bill 719.
Good afternoon. Good afternoon, members of this Judiciary Committee. I am honored to be before you once again, and I'm here to ask for your favorable report on Senate Bill 719, Criminal Law, Crimes Against Minors, Sensitive Locations. The critical issue of human trafficking and/or sexual offenses involving minors demands our immediate attention and action. Maryland, due to its strategic location near major transportation routes and its proximity to Washington, D.C. and Virginia, has unfortunately become a focal point for these atrocious acts. It is both alarming and heartbreaking to acknowledge that many victims of this crime are students from our schools and colleges, often targeted and exploited right under the protective guise of our educational system. The data presents a grim picture indicating that a considerable portion of minors entangled in human trafficking and/or sexual assaults are found within our schools, with recruitment efforts taking place in what should be safe learning environments. This situation is further aggravated by the vulnerabilities associated with specific demographics. Globally, children constitute 27% of all human trafficking victims, with girls representing a substantial majority. Locally in Maryland, over half of the juvenile victims of sex trafficking are African American youth, emphasizing the disproportionate impact on certain communities. Further, the fact that the average age of entry into sex trafficking is only 12 years old, that underscores the urgency and the need for intervention. To combat this crisis, Senate Bill 719 proposes stringent penalties for trafficking and/or sexual offenses committed in proximity to schools and other child-centric areas. This legislation aims not to just penalize, but to prevent, serving as a strong deterrent to those who would prey on our young. By imposing an additional sentences up to 5 years, and I want you all to know that we have put it in an amendment to the bill, which I will offer in just a few moments, for juvenile offenders, and up to 15 years for adults, another portion of the amendment. Senate Bill 1717 seeks to transfer our educational environment into havens of safety rather than zones of risk. The introduction of 719, Senate Bill 719, marks a significant stride toward eradicating human trafficking and protecting our youth from exploitation. It amplifies our legal framework to shield the most vulnerable members of our society, our children, from unthinkable harm. In closing, I ask this esteemed committee for your favorable report on Senate Bill 719, reinforcing our shared dedication to the security and well-being of our children. Now, this bill is being amended to House Bill 719. And page 1, if you look at the bill, in line 24, we want to strike 5 years to 3 years. On page number 2, beginning with the colon in line 15 down through 2 in line 18, and strike beginning with the comma on line 18 down through minor in line 19. On page number 3 in line 3 and 28, in each instance, strike 5 and substitute 3. I respectfully urge you to give full favorable response to Senate Bill 719. And I have to tell you, I do get a little tired of us coming every year talking about this whole big problem of human trafficking. It's really shameful that we have to come here every year. I just wish that the time would come after over 25 years, I could come to Annapolis and we would not have to talk about human trafficking. It really is shameful when they prey on our children. It is unbelievable. And I am just hoping that you all are serious about this bill and do something with it and pass this bill, because we've got to serve notice to these people. I was going to call them out of their name, but that's not acceptable. These people need to understand that this is serious when we're talking about our children. It's unacceptable. Anything that happens to children that's not good is not good for us. I will answer any questions.
Senator, as always, it's a pleasure, and I can assure you the committee reflects your sentiments, but we'll hear from Senator Folden first.
Thank you, Mr. Chair.
Is your question going to be difficult?
It's going to be you better brace yourself, Senator. It's going to be a doozy. Where you going? I just want to say thank you for bringing the bill. I am a firm supporter in your enthusiasm for protecting those vulnerable, and look forward to working with you on this. I love it, and thank you for bringing the bill.
Well, you know.
Isn't
to
that
be
so?
honest with you all, one of the reasons why I continue to hang around down here is that I want it to be better for our children. I really do. And this is one of the areas that really troubles me. When we have our baby children, they can't go to the playground, can't go to school, can't do anything because they are subjected to this foolishness from these people who are out to make millions and millions and millions of dollars on the backs of our baby children. That's shameful.
Hey, I appreciate it. Further questions from the committee? That was good. All right. Thank you very much, Senator. We have a panel.
Thank you very much.
The distinguished state's attorney from Prince George's County, Aishbre Boy, was going to join us virtually. He's not here. Okay, so then we'll move on to the opposition panel. Someone who's also joining us virtually, Miss Brenda Jones.
Hello, this is Brenda Jones, and I am with Families Advocating Intelligent Registries. And I'm here in opposition of Senate Bill 719. Families Advocating Intelligent Registries seeks rational constitutional sexual offense laws. And we are especially concerned with this particular bill. We appreciate that the Senator has reduced the 5-mile radius in the original bill to 3 miles. In your printed testimonies that you should all have received in your materials, on the back of ours, you will see circles showing the 5-mile radius. Without too much effort, you could probably take a look and guess what those circles might look like with a 3-mile radius. We still feel that that would be, it's an excessive distance to consider that to be within proximity of schools, and not a practical way to consider that this is a sensitive area when you're talking a distance that's so large. We are also concerned that this bill, by creating a penalty at such a wide range and covering, adding in these new areas, that it's creating some felonies out of what is misdemeanor activity. If we're reading it right, there's a lot of misdemeanors that fit under that description in the new area. And since practically anybody in the state is going to wind up being subject to this based on a 3-mile radius, you're basically changing all of that into felonies, at least to a small degree. So with that, I just do want to encourage the committee to vote no on this legislation. Thank you.
Excellent. Thank you very much. Questions from the committee? Seeing none, that'll conclude the hearing for Senate Bill 719. We'll now move on to Senator Sidnor with Senate Bill 661.
All right, good afternoon, Senator Sidnor for Senate Bill 661. Senate Bill 661 is a minor yet crucial change to our law. Current law requires each law enforcement officer who regularly interacts with members of the public as part of their official duties to use body-worn cameras. Senate Bill 661 alters the law slightly, requiring the use of body-worn cameras by each law enforcement officer, regardless of rank, to use a body-worn camera while the officer is in uniform in public and conducting law enforcement-related duties. If you check out my written testimony, I talked a little bit about why this tool is such a vital tool, but I'm not going to get into that. I know we have a long day. So with that, I respectfully request a favorable report on Senate Bill 661 and turn this over to our panel.
Good afternoon again. Michael Davey, General Counsel to the Maryland State Fraternity Order of Police, and we're requesting a favorable report on Senate Bill 661. The purpose of this bill is to make it very clear that all sworn law enforcement officers, regardless of their rank, wear and be required to use body worn cameras while they're in uniform, in public, and conducting law enforcement duties. Consistent with the law, every law enforcement agency is required to write their own policies as it relates to who and when a sworn law enforcement officer wears and activates their body worn camera. They write their own policies. The bill makes it clear that a chief and his command staff will have the same responsibilities as their rank and file as it pertains to wearing and activating their body worn camera. The passage of this bill will prevent a chief from writing a policy that would exclude him, her, or any sworn officers, regardless of their rank, from the requirement of wearing and activating a body worn camera while in uniform, in public, and conducting law enforcement duties. This is simply one of those cases that chiefs and sheriffs are going to enforce body worn camera violations on the rank and file. They should be held to the same standard. While many chiefs do wear them, many chiefs don't. And we simply don't want them to have the ability to write their own policies and writing themselves out of the requirement that the law requires. Thank you.
Good afternoon, everybody. I'm Lieutenant Elliot Cohen. I'm an executive board member and state trustee for Baltimore City Lodge, FOP Lodge number 3. And I'm here today on their behalf. I'm speaking in favor of the bill to expand the body worn camera requirement to all sworn members of police agencies, regardless of rank, to include command members. Although reluctant at first, most of our members have found wearing body cameras extremely valuable. Both officers and the public have found having their interactions recorded have improved those interactions. In general, studies have shown that body worn cameras improve professionalism and lower complaints. It makes sense that the benefits of body worn cameras should apply to all sworn members of an agency, to include those in the command ranks. Basic fairness follows that the rank and file officer should be held to the same standards as their commanders. It should be concerning that leadership in police agencies opposed to wearing body worn cameras are advocating to be held to a lower standard than their own officers. Departments already have policies in place to handle privacy issues and limit activation to law enforcement activities. For these reasons, we're in favor of the bill. Thank you for your time.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of the committee. My name is Ari Plout. I'm here on behalf of the Fraternal Order Police in support of Senate Bill 661. Thank you, Senator Sidnor, for sponsoring this legislation. As my colleagues have stated, this bill would just essentially expand body worn cameras to require command staff to wear body cameras similar to how our officers are currently required to. We would ask the committee to reject any amendments. We believe that the amendments are an exemption for the command staff. So we would request that the committee support the bill as written. We believe the bill it's a pro-transparency, pro-accountability bill. I don't need to repeat everything my colleagues have stated. We ask for a favorable report. Thank you.
So thank you very much, Senator Folden.
Senator, whoever wants to stand up and answer it, I mean, I'll just start with you. How's that?
Sure.
So I'm just curious, under the original crafting of the legislation, it talks about that every law enforcement, that body worn camera policies and the use of body worn cameras was to be developed by law enforcement agencies, and that each law enforcement officer employed by the law enforcement agency who regularly interacts with members of the public as a part of the law enforcement officer's official duties. And that's been stricken, the part about who regularly interacts with members of the public, and you're looking to add while the officer is in uniform, in public, and conducting law enforcement related duties. So I have a couple questions. One is this just coming from like everybody's worried about a say as I do or do as I say, not as I do? Because I know of zero interactions that have risen to the level of what you're asking.
It's a consistency issue. What we've seen is some agencies have written policies that the chief or the head of the agency and its command staff simply don't even get assigned a body worn camera.
So a law enforcement related duty then. So a supervisory or a supervisor at a law enforcement agency is a part of his law enforcement duty guiding and dispatching or deploying his employees?
It is.
Okay. So at that time, he has to have it on regardless of where he's at, right?
I would,
According to this.
yeah, I would argue the way the bill is written, yes, that would cover everything.
Okay. So an executive law enforcement official, your command, and not even talking about lieutenants, I'm talking about your chiefs, assistant chiefs. What is their law enforcement related duties?
I mean, they
on a
can-
daily basis?
On a daily basis, it's generally administrative.
Are they
but
distinctly different than that of a member of a department that deals with community members and is involved with investigations on a daily basis?
Correct. What I think what the goal of the bill is to ensure that every chief and command staff is assigned a body worn camera, is required to activate it when they're taking some form of a law enforcement action.
And if the chief or sheriff says, you know what? I don't want to, I'm not going to wear it. What's the bill provide?
I think it would be disciplined just like any other. I don't know who's going to make the complaint against the chief.
Who disciplines a sheriff?
Unfortunately, if it involves an interaction with the public, there'd be an investigation and it would go to the administrative charging committee.
Who is responsible? Who can dismiss a sheriff?
Dismiss?
Yeah. Who can punish a sheriff?
Being
Exactly.
an
So we
elected
have a lot of-
official, it would be difficult.
Correct. So there are different standards here. You have sheriffs who are elected, they answer to the voters.
Yes, sir.
So technically they could be, if it happened the day after they got in office, it could be 4 years and they're not gonna have anything because they're distinctly separate. Their role, their mission, their executive responsibility to the department is different. While they all still have the same law enforcement responsibility and should it rise to the level of powers of arrest and authority as a law enforcement officer has, overwhelmingly, not even by a little bit, overwhelmingly, their job is executive, administrative, in the office. But the way this bill is written, if they go out and are, you know, if a scene happens, right? And they go out and they're there to navigate, you know, and be there with their troops and be like, hey, what do you need? What can I help you with? Technically, as this is written, they'd have to have their camera on.
Correct.
And they'd have to have it activated.
Correct.
Okay. So I don't understand the part about where we're saying we're showing two distinct responsibilities that was covered in the initial bill, which was regularly interacts with members of the public, versus now you're wanting it anytime they're in uniform, in public, conducting law enforcement related duties, because law enforcement related duties could be something as simple as directing employees. And if they don't turn it on, by the way this is written, they would be could be subject to discipline.
That's correct.
Even though they're not on the scene.
I think the goal of the bill was to ensure that chiefs, sheriffs, command staff follow the same rules as they set for its members. And I think that was the goal. So I think what we might be able, the intent is what our intent was. I think you understand that.
Correct.
We're trying to make sure that chiefs are held to the same standard as their rank and file. That is the goal of the bill. And if it can be tweaked and reworded a little bit, we will take a look at that.
But we can agree that a chief or sheriff's responsibility is wholly different in the law enforcement arena than that of, say, anyone from lieutenant down.
When you use the words law enforcement duties, yes, I can agree to that.
Thank you.
All right, additional questions from the committee? Seeing none, thank you all very much. All right, we have a few more witnesses signed up and I'm not sure I see all of them, but is Clyde Boat right here? Jerome Spencer? Frank Boston? And we have, is Ms. Levy here? All right, take Piper in.
Good afternoon, Mr. Chairman, members of the committee. My name is Jerome Spencer. I'm here on behalf of the Maryland Chiefs and Sheriffs Association, and we support this bill with amendments. And I appreciate the conversation we just heard from the sponsor and from the other people on this panel, because it helped clarify for us what the purpose of the bill is. When we first reviewed this bill, our attention was drawn to the same phrase that Senator Folden focused on while conducting law enforcement related duties. We weren't really sure what that meant. There's some concern that means when the chief or sheriff is engaged in a budget negotiation with the county exec or with the county council or whoever it may be, well, that's law enforcement related duties. When the chief or sheriff is doing a town hall meeting with the public, Well, he's in uniform, that's law enforcement related duties. They seem to go a bit above and beyond what we want body worn cameras for, and the goal body worn cameras have. Now, the Maryland Police Training Commission sets up guidelines that each agency policy has to have and has to follow. Each agency required to incorporate those guidelines in their policy. And the grand picture of same rule for the command staff as the police officers, I don't think there's an objection to that stated goal, but this bill doesn't seem to do that. By adding phrase in uniform, in public, doing law enforcement related duties, and we don't know what that means, I'm not sure the bill accomplishes that goal. But we suggest some amendments to the FOP, and I think to the sponsor too, talking about that phrase, using a different phrase, using the phrase the commission uses in their guidance that might narrow the scope of when the camera is expected to be on, arrest, use of force, traffic stops, that kind of thing. And we're happy to continue to work with the FOP and with the sponsor, and maybe reaching the goal language makes sense between the two parties. We're just not quite there yet. Thank you.
Thank you very much. Do we have your amendments in our file? Do you have them in your testimony?
I'm told yes.
Yes. Okay, excellent. Thank you. Yes. All right. Thank you very much. Ms. Levy, you're up. Welcome. Good to see you.
Thank you. Thank you. Good to see you as well. This is Debbie Levy from the Office of the Public Defender, urging a favorable report on Senate Bill 661. We echo the concerns. I think that was Mr. Davey speaking on consistency. And what we found in practice, from a very sort of practical perspective on what's happening across jurisdictions since the body-worn camera law was first enacted, and we see large major metropolitan police forces just illogically exempting whole groups from wearing body-worn camera. For example, in Baltimore County, detectives are exempt from wearing body-worn camera by an internal policy. We can't figure out the rhyme or reason to that policy. Certain groups in Baltimore City who are interacting with the public in law enforcement activities are also exempt by internal policy from wearing body-worn camera. I'm not actually sure that that policy is helping law enforcement as much as it might be hurting, but the fact that this legislation would absolve police departments of the ability to create these illogical inconsistencies, I think that this would further appropriate goals, and we urge a favorable report.
Thank you very much. Questions from the committee? All right, seeing none, that'll conclude the hearing for Senate Bill 661. Thank you all very much. We'll now move on to Senate Bill or Senate Resolution 1. Senator Kelly.
Hello, members of the committee. Thank you. I've never done a resolution before. So first of all, forgive me. I've never found one important enough to do before. I am a little bit shaken to note that I'm looking around at a room and I see the committee manager and a bunch of men as I present this bill. This is not the room I had in mind when I prepared this testimony, but please bear with me and be kind. Okay, so first of all, I was going to start by opening with a little rap because I thought you would appreciate that. But and here's why. Okay, anybody here seen Hamilton? Anybody? Senator West, Senator Meade, yes. Okay, only the two of you, really? Okay, right. Senator Sidner has seen it. Okay, so a lot of people think that that masterpiece was about Alexander Hamilton, and that's the genius, right, of this art, is that was really about us all. It's about immigrants and people of color and low-income people. It's about women. We can all see ourselves in that great American story. That's what made Hamilton genius. For me, when I see Hamilton, the story is actually about Angelica Schuyler. This is the part where I was going to rap, but now I'm definitely not going to rap because Charles walked in the room. But, you know, there's the point in that song where Angelica Schuyler says, "We hold these truths to be self-evident that all men are created equal. And when I meet Thomas Jefferson, I'm going to compel him to include women in the sequel." And that one line in that beautiful, brilliant play made it about me, right? And that's the potential of our beautiful country. Our Constitution is aspirational. It is a vision statement, right? The introduction, "We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, secure the blessings of liberty to ourselves and our posterity, our children." This is who we have in mind, right? It's an aspirational vision for a nation that is a work in progress. The equal rights for women really need to be a part of that vision. That's why I'm here with a resolution. I think resolutions are silly, and I think this is an important one, right? It's about including women in the sequel. Okay, so I have read in the newspaper that this resolution might be about virtue signaling, which it is absolutely not. So I hope you can hear my voice shaking, right? Because this is important. It is essential to my soul. I hope you can hear that. It is not about one issue or another, as much as I might want it to be. It is about affirming the Equal Rights Amendment. The choice to do that is not going to guarantee outcomes on any specific policy issue related to women that my panelists and I care about, right? Any more than the 15th Amendment that was ratified in 1870 immediately ensured that Black men had access to the vote. It did not. Progress takes time. This country is a work in progress, and we are constantly moving towards justice. I want to give you a brief history because this is just a resolution and I do not want to take too long. But I think most of us, I have a women's history degree, so I know this stuff really well. Most of us don't know this, right? The idea of the Equal Rights Amendment originated in the 1920s after the 19th Amendment granting women the right to vote on paper was ratified, because keep in mind, Black women still could not access the vote, right? Black women and low-income women also had difficulty accessing the vote. Nonetheless, the idea came about to add in this simple line: equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Really simple addition. The movement to ratify the ERA was silenced by a backlash to the women's movement in the 30s and the 40s and the 50s. And then it was revived again in a bipartisan effort throughout the 60s, 70s, and the early 80s. There were lots and lots of Republicans who supported the ERA, including the first woman justice of the Supreme Court, Sandra Day O'Connor, including Senator Margaret Chase Smith, a Republican who was the first woman elected to the House and the Senate. She has some great quotes on this. One of my heroes, Betty Ford, and her husband, Jerry Ford, Dwight Eisenhower, Richard Nixon. Every Republican president from 1940 to 1976 supported the Equal Rights Amendment. Today, even Lisa Murkowski and Susan Collins do. Here's what you need to know about Maryland's history related to the ERA. In 1972, we ratified the ERA. Ben Cardin and Steny Hoyer were here early in their careers, here in the Maryland General Assembly, here for that vote. In 1972, we also passed a state constitution ERA. That's a change to our state constitution that went to the voters across the state of Maryland. It passed overwhelmingly. It passed in every county except for Garrett County. So I guess Senator McKay gets a pass, but everyone else, your people have already voted on this back in 1972. The movement for the federal ERA stalled. We needed 38 states, 35 states ratified it. We were 3 states short when the campaign went into hibernation. I'm going to tell you a little bit about why that happened. So the women's movement of that era really changed the world. I wish that Senator Carter were here because she knows this, right? It used to be that women could not serve on juries. They could not have credit in their own name. That has changed. Women entered professions in significant numbers, but that led to a major backlash, right? And that halted progress on the ERA. And for a lot of people, that was just heartbreaking. Can you imagine getting so close, 35 of 38 states, and not crossing the finish line? But that's what happened. That's what happened in American politics. A woman named Phyllis Schlafly and the Eagle Forum used some scare tactics to organize conservatives to oppose women's rights. And they shifted the position of some Republicans on the issue. They argued that the ERA would eliminate special protections that women enjoy under the law. Not all women were enjoying those special protections. That it would lure women out of the kitchen and away from their natural and only role as homemakers, and that it would lead to what they considered would be horrifying social changes like gay rights and women's economic empowerment and military participation for women. So this movement is the same movement that organized against the public child care system and convinced Richard Nixon to veto the public child care bill. It was one of the most devastating and stunning defeats in American political history, and that's why I weep before you. It was a devastating defeat. I can imagine if you were on the side of the Confederacy during the Civil War, that would have been worse, but I don't have a lot of sympathy for those folks, right? Besides that, I can't think of a worse major defeat for such a long-standing movement. The organized women's movement retreated to lick our wounds for 4 decades on this issue. In the 90s and the early 2000s, the ERA campaign was gone from the headlines. It was gone, but not forgotten, because the arguments of the opposition just did not stand the test of time. The people who organized the opposition were uniformly affluent. They were overwhelmingly white. They were women who were not working for wages. They were heterosexual. They were cisgender. They were married to property owning white men. They weren't representative of the diversity of women in the United States. And their worldview was very narrow. The opponents couldn't imagine a world where women didn't choose to completely depend on a man for their economic and legal needs. The opponents didn't even acknowledge that the majority of Black women and low-income women and immigrant women like my grandmothers have always been in the workforce in the United States of America. They certainly didn't imagine a world where more than 50% of medical students and law students would be women. They couldn't imagine that world, but today we live in that world. We have had a lot of success, but we still need the ERA, right? Because when the next backlash comes, our rights will stay protected. In 2017, after a 35-year pause, states returned to ratifying the ERA. In 2017, again, a bipartisan vote in Nevada ratified the ERA. In 2018, in Illinois, a bipartisan vote followed. In 2020, in Virginia, they became the 38th and final state we needed to ratify the ERA. Again, Virginia, that was bipartisan. 7 of the Republican senators supported that vote in 2020. It's Maryland's turn to help. So I'm here with a resolution. Sometimes we laugh at resolutions, but it is really important. There was a beautiful rally held by the Women's Caucus on Monday. This is the Women's Caucus's #1 priority bill this year. It was an intergenerational rally, and it was a beautiful experience. Many of you know and are dear friends with a woman by the name of Gloria Lala, who served with us in the Senate and was our Secretary of Aging. She spoke at the rally words that I will never forget. She said, "I am not going to my grave before I have done this for my granddaughters." Delegate Woods, who has the most beautiful singing voice, sang the national anthem. And we turned to look at the US flag and the Maryland flag as she sang that national anthem. And we thought of the promise of this country. And at the same time, I was so proud that the Maryland Constitution has the ERA in it. And I looked at the Maryland flag and I had that pride. I looked at the US flag and I thought, we can do this. We can do this at the federal level. So that's why we have this resolution. It is calling on our federal partners to pass a joint resolution, striking the deadline and affirming the ERA. We would be joining states, including Minnesota, Colorado, Illinois, Hawaii, and California, who have already done so. Our position, which is shared by the Attorney General of Maryland, you have a letter from him in the file, states that 28 states have ratified, that the requisite number have ratified the amendment, and that it should be the 28th Amendment. Calls on Congress and the Biden administration to affirm that. That's all the resolution does. As I mentioned, it's a top priority for the Women's Caucus, but it is also a priority for the Maryland Legislative Agenda for Women, the Young Feminist Party, the Women's Heritage Center, 100 Black Women, National Council of Jewish Women, LGBTQ+ Chamber of Commerce, League of Women Voters. And we have just a couple of panelists here today to talk to you about why they're supporting it. We understand that a constitutional amendment won't solve all of our problems. It is a starting place. We are asking for you to include women's equality in the U.S. Constitution. This is the one thing we can do. It's just a resolution. With that, I urge a favorable report, and I hope you will listen to the testimony of just a couple panelists. And if you're on the fence, review a lot of written testimony in your file. Thank you.
Good afternoon, Chair Smith, Vice Chair Wallstreicher, and members of the committee. I'm Tazeen Ahmed. I'm the president of the Montgomery County Women's Democratic Club. WDC is one of Maryland's largest and most active Democratic clubs, with hundreds of politically active members, including many elected officials. And we urge you to pass this resolution to clearly affirm the Federal Equal Rights Amendment meets the requirements of Article 5 of the U.S. Constitution, and to ask the Congress to finally certify and publish it. Maryland has long been a leader in the battle for gender equality. And as you already heard, we ratified the ERA 2 months after it was sent to the states for ratification by Congress in 1972. We later enacted our own state ERA a few months later. But that's not all. There is precedent to the resolution that's here before you today that dates back all the way to 1961, when Maryland became the 4th state in the country to pass a bill urging Congress to adopt the ERA as a constitutional amendment. Maryland has been on the right side of history in the fight for gender equality, but the work is not done. Today, we urge you to take up this cause again, because while Maryland does have the fortune to have state ERA protections in place, without a federal ERA in our Constitution, our state constitutional protections could be jeopardized by federal courts, including the Supreme Court, or by Congress. To maximize our impact, WDC has joined Maryland Now, Free State Justice, and AAUW Maryland to create the Maryland Equal Rights Action Network, MERIN, to coordinate ERA advocacy's efforts across the state. This network includes organizations from Garrett County to Talbot County, from local commissions for women to LGBTQ+ advocacy groups, Black women, university women, business professionals, and more. The time is now. The ERA must be affirmed and published as the 28th Amendment to the Constitution, and we ask for your support and strongly urge a favorable committee report. Thank you.
Good afternoon, Chairman Smith, Vice Chairman Waldstreicher, and honorable members of this committee. My name is Katie O'Malley, and I am the Executive Director of the Women's Law Center. So, of course, I am here in that capacity to urge a favorable vote on this resolution. But not only as the Executive Director of the Women's Law Center, I am a woman and I'm a human. And this resolution here affirming the ERA makes sense to me just as a member of the citizens of our country here. Back in 1972, the legislature in Maryland passed the ERA, ratifying it here for the state of Maryland. I was 10 years old. My father was in the Senate at that time, and he was proud to be able to vote in favor of that. Now it's imperative, now even more it's imperative, that that our Constitution explicitly states that women and people across the gender spectrum are equal to men, and to affirm that gender-based discrimination is unconstitutional. This is especially important now considering recent attacks on women's rights and the rights of members of the LGBTQ+ community. I am not going to take my entire 2 minutes because I'm sure there may be some questions about the constitutionality of our getting this ratified and having the archivist publish this so this can in fact become the 28th Amendment. And I'm prepared to answer some questions specifically about those legalities. But thank you again for taking this resolution and considering that completely heartfelt testimony from Senator Ariana. I defer.
Afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Jakia Johnson, and I'm the Executive Director of Reproductive Justice Maryland. And I'm here today to express my strong support for this joint resolution. The ERA, which will constitutionally guarantee equal legal rights for all citizens, regardless of sex, is long overdue for certification. And while strides have been made over the years to advance gender equality, the absence of constitutional protection for women remains a glaring gap in our nation's legal framework. The link between the ERA and the reproductive justice movement cannot be overstated. When Roe v. Wade was decided in 1973, it established the constitutional right to privacy as the foundation for reproductive rights. However, as we've all witnessed, the absence of explicit language affirming gender equality in the Constitution left those rights vulnerable to attack. While Roe was rooted in rights that flow from privacy, not equality, the ERA would have provided a constitutional basis for upholding reproductive freedom as a matter of gender equality that would have served as a powerful defense against those attempts to restrict reproductive rights. Finalizing the ERA is not only a matter of justice, but also a pragmatic step forward for protecting reproductive rights on a national scale. The ERA provides the clearest path forward to restoring and preserving national reproductive rights, ensuring that all individuals have the autonomy to make decisions about their bodies and futures without fear of discrimination of government interference. I respectfully request a favorable report on the joint resolution to affirm, certify, and publish the fully ratified Equal Rights Amendment. By doing so, Maryland can take a significant stand in support of gender equality and reproductive justice. Thank you.
All right, thank you very much, Senator. Thank you for your passionate testimony. I really enjoyed it, and I enjoyed the panelists. So thank you. We'll go Senator West.
Thank you, Mr. Chair. Judge O'Malley, can I ask you a question? And it is a genuine question, which I don't have the answer to. So once 38 states have ratified a proposed constitutional amendment, what is the process for officially making it a part of the US Constitution?
So the 38th state that did ratify it was Virginia, and that was in 2020. So now what we have is we have 2/3 of Congress have already accepted the amendment. And then we've had in 2020, the 38th state ratify. So now really what the constitutional experts, so Lawrence Tribe of Harvard, and then Russ Feingold, who is of the American Constitution Society, they believe, and they have strong arguments to believe, that the archivist of the United States only now needs to publish it, that we really don't necessarily have to have President Biden. Certainly it would be under his administration. So it would be his administration and Office of Legal Counsel that would give give legal counsel on it, but that the archivist right now has the authority to do it. That's based on those two legal experts.
And that's all that has to happen. So there's an individual whose position in the federal government is archivist. And if the archivist publishes it?
Correct.
Publishes it
to make it
constitutes officially making it part of the Constitution.
That is generally the procedure. And this sort of time period that was given in the preamble, not in the amendment itself. So in the preamble of the 28th Amendment, Equal Rights Amendment, it says that there should be this 7-year time limit. And then that was extended. So when we didn't have the full 38 states after 7 years, that was extended by Congress. But what these constitutional scholars say is that that's sort of a made up thing, and that amendments don't necessarily have to have that there's really no basis for it.
All right. So it sounds as if at any day, on any day, and indeed back to the time that Virginia ratified the amendment, the archivist at any time could have published the amendment and officially made it part of the US Constitution. And then that, of course, would have engendered lawsuits, which would have gone up to the Supreme Court as to whether the archivist was correct in that publication. Okay.
Correct.
Thanks.
So and that all started under it was Congresswoman Carolyn Maloney has been really starting to urge this since 2020 when Virginia ratified it.
Yeah, it was a genuine question. I had no idea once states have ratified it and a proposed amendment, how it officially becomes part of the US Constitution. And you've clarified that. Appreciate it.
Thank you. And thank you to Senator Kelly for bringing this important bill. And Senator Kelly, can I be a co-sponsor?
Yes, please.
Thank you. Okay, that's just, I don't know if you touched on this. I apologize for being out of the office, but I'm wondering, given the Madison Amendment, you all just touched on the Madison Amendment and taking 202 years to get ratified. And part of the reason was that it did not have a time deadline in the body. But I was trying to look up, is there any discussion about how to compel the archivist to do his duty? And I'm thinking of a writ of mandamus, but I'm just trying to think about why nobody, since we've had 4 years since Virginia, right? 4 years. Has anybody discussed how we might compel the archivist to carry out his duty? Has that been a subject that anybody has discussed? Okay, I see so someone else will probably make mention of it, I hope.
Yeah, I can't answer that other than to say that this is part of a national campaign to try and build momentum to do that. So I mentioned five other states have passed similar resolutions. We would like to join them, and there are a number of other states that are considering resolutions. So that is part of sort of the outward pressure.
And then Senator Kelly, I'm hoping you'll address this. I came into a discussion about Roe versus Wade, but in my opinion, this amendment is important regardless of where you fall on that issue, right?
Absolutely.
Women
absolutely
are not protected in the Constitution. If you want, I'd like you just to address briefly that wherever you fall on that, that's an issue that's unsettled. I don't know what would happen to it, but for that to be the reason.
Yeah,
that
so
women
it's
and
it's very
others would
interesting
not
because
support us.
Maryland has an equal rights amendment in our state constitution, and yet we still are following up with the amendment that's on the ballot this year for voters regarding reproductive freedom.
Right.
Because the two do not completely overlap. This is about equality under the law, regardless of your sex.
Thank you. Thank you, Senator Kelly.
Thank you very much, Senator James. I have a question, just some of the history, and maybe Judge O'Malley. There was a kind of this legal fiction of a 7-year window created initially. It was extended, I think, 3 years, and then there's a House resolution that was passed to remove that artificial timeline. It's moved into the Senate now, pending, I think.
Correct. It hasn't been taken up for a vote yet.
Yeah, but that whole thing is probably just a belt and suspenders, not necessarily needed if the archivist could go forth and just, since we've reached the 38 state threshold in 2020, do this. It's probably something that is belt and suspenders, but is that right?
So that's what these scholars that like Russ Feingold, who used to be a United States Senator from Wisconsin,
Yeah.
and he was head of judiciary in the Senate. That's his analysis of it, is that that's not even necessary, because it wasn't written in the amendment, this whole 7-year, extension, or the 7-year timeline to get it done, and then 3 more years. So it was not even part of the actual amendment. And that's the same argument that Lawrence Tribe, the Harvard scholar who I see on CNN all the time. I don't know how to properly, say all of the things, the accolades about him, but that's also his analysis. So
We add Jamie Raskin to that mix. And
yes, and we will
got a good-
certainly
got a
add
good
America's
list there. All right.
congressman to that. Yes.
Yeah. Well, thanks. No, we look forward to advancing this bill through. So thank you very, very much. Further questions from the committee? Senator James, are you?
No, I'm delighted, and I just think that the whereases in here are just so well done and great legal basis for why this should happen. And I'm just hinting at writ of mandamus if the archivist doesn't proceed.
That's great. All right. Well, thank you all very much. Thank you.
And I think Camila Dominguez is over in the House, so she couldn't be here. I'm not sure if
she's here.
Oh,
I'm here, but they did a great job. She's just going to do a me too.
2 thumbs up, me too. All right, excellent. So that'll conclude the testimony for the proponents of the bill. We'll now hear 2 folks we have signed up in opposition. Oh, is Rebecca Snyder here? Oh, hey, there you go. Hey, right front. I'm gonna make sure you get a chance to.
Good afternoon, committee. I'm Rebecca Snyder. I'm here representing Executive Alliance, which is a professional women's organization that covers all sectors. We're based in the state of Maryland, and we seek to take women's power at the highest levels of leadership. We stand in wholehearted support of this Senate resolution and thank Senator Kelly for bringing it forward. I really cannot add more to what the panelists on the proponents and the former in the panel before me said, except to urge you to re-ratify. Maryland has a strong history of standing with women. We were one of the very first states to ratify this way back in 1972. It is overdue, even as a belts and suspenders measure. Women's rights and equality under the law is too important to leave to, pussyfooting around with an archivist and so forth. So I urge you to pass this favorably. Thank you.
Oh, yes, Camille. Yes, you're signed up. So come on up.
Good afternoon. My name is Camila Reynolds Dominguez. I just have one other thing to add, which is reflected in my written testimony, but I do think it's important to articulate here. The final whereas clause in the resolution articulates a kind of comprehensive understanding of what constitutes sex-based discrimination. And that's really important to pass this session, especially in the wake of the John Doe v. CRS case. So the way that I read it, it kind of this language in the final whereas clause squarely rejects some of the bad statutory interpretation from that John Doe v. CRS case. So that's just the last kind of piece there. And I thank you for your time today.
Excellent. Sorry, Senator. Sorry, guys. Senator James.
can you, is it Senator West or me? Okay, hi. Thank you for sharing that, but could you just give me that, it's a case, could I just, the last whereas, I don't see on page 4, lines 11 to 17, I don't see a reference to the case, so would you
Right.
just give me that case again so I can look it up, please?
Sure. It's called John Doe v. CRS, Catholic Relief Services. It was decided this past August. Among several things that the case did.
What jurisdiction was it in?
Maryland Supreme Court.
Maryland Supreme Court.
The Maryland Supreme Court said that for the purposes of Maryland law, discrimination because of sex does not include discrimination because of sexual orientation and gender identity. And this is directly contrary to US Supreme Court precedent in Bostock v. Clayton County, where Justice Gorsuch said, you can't discriminate on the basis of sexual orientation or gender identity without also discriminating against that person because of their sex. So this helps set that record straight, in addition to SB 590, which you all heard a couple weeks ago.
Thank you. Thank you very much.
Senator Lamb's bill.
Yes.
That's right.
Okay.
All right. Further questions? Excellent. Thank you very much. Thank you.
very much.
All right. So that'll conclude the testimony for the proponents of the bill. We'll now move on to the opposition panel and we'll hear from Ms. Bogley. And then we have someone joining us virtually, Mr. Douglas Johnson.
Thank you, Mr. Chairman and members of the committee. I'm Laura Bogley, Executive Director of Maryland Right to Life. And on behalf of our members, I ask you to uphold your oath of office to defend the Constitution of the United States by issuing an unfavorable report on this erroneous resolution. You heard a lot of information, a lot of it inaccurate. There have been at least 6 federal courts who have heard and issued opinions on this issue. 29 federal judges, equally divided Republican and Democrat appointees, and not a one of them has said that the ERA from 1972 is still alive or may be revived, short of new introduction from Congress. This resolution attempts to incite an executive fiat to circumvent the Congress and the Supreme Court and to force the failed Equal Rights Amendment into our Constitution, despite the will of the many states who refused to ratify it. ERA proponents once hid behind the mantra of equal rights for women and refused to admit that the ERA was an integral part of their abortion on demand agenda. Abortion until viability has never been enough for them. But after the fall of Roe, abortion extremists are demanding unlimited taxpayer-funded abortion by any means necessary at anyone's expense, including women and children, as well as the integrity of our Constitution and our courts. ERA activists create division between mothers and children. It is a lie and an injustice to tell women that we can only achieve equality by killing our children and rejecting our biological superior role as mothers. It is through our role as mothers that women can have the greatest impact on the world and on its future. The ERA would not empower women, but would empower men to continue to exploit women and evade all responsibility for the upbringing of our children. The ERA would empower the abortion industry to wield a monopoly over women's reproductive health and deny women access to life-saving alternatives to abortion if that is what they so choose. The ERA would force taxpayers to fully fund elective abortions through birth with no exceptions and no safeguards in law for women, children, or medical providers who refuse to commit abortions. Congress and the Supreme Court and the people have spoken. The ERA is anti-woman, anti-family, and anti-American. We urge your unfavorable report. Thank you.
Thank you very much. All right, we'll take, we have Mr. Johnson is here joining us virtually and we'll take questions after that. Mr. Johnson, if I know you're off mute, if you could make sure that you're, if you're streaming us, if you could just make sure that the browser is muted on YouTube.
Yes, Senator.
Excellent. We are ready to receive your testimony. Welcome.
Mr. Chairman and members, I am Douglas Johnson. I am a 40-year Maryland resident. And for even longer, I have been studying and writing about legal and political developments relating to the proposed federal Equal Rights Amendment. Now, the 32 whereas clauses in Senate Joint Resolution 1 that's before you boil down to 2 major assertions. The first claim is that the ERA should now be published as part of the U.S. Constitution on grounds that the ratification deadline was not binding because it appeared in the preamble, or what is properly called the proposing clause. And yet SJ1 simply ignores the unbroken chains of federal court decisions over a 42-year period that contradict that claim. For example, In February 2023, a three-judge panel of the DC Circuit unanimously rejected the pleas of Illinois and Nevada that the archivist be ordered to publish the ERA. The ruling was written by Judge Robert Wilkins, an appointee of President Obama. The court squarely addressed and utterly crushed the argument that the preamble placement of the deadline rendered it ineffectual. That appears on page 25 of the unanimous ruling. There have been many others which are addressed in my printed submitted testimony. So SJRES 1 implicitly appeals to the president and other federal officials to ignore the law as clearly expounded by the federal courts for 42 years and to hearken instead to the politics. Now, SJRES 1 also asserts the states may never rescind the ratification. Yet just 10 years ago, a previous chairman of this committee, when he learned that Maryland was among the handful of states that had ratified the pro-slavery Corwin Amendment, Senator Frosch said this was a blight on the state. He introduced a rescission resolution, and it passed with much favorable commentary and coverage in the news media and was transmitted to the archivist. Yet we read in this resolution that rescissions are always unconstitutional. So in closing, I would just say, if you're going to pass this, you should amend it with a PS to say to the archivist, please send us back our rescission on the Corwin Amendment because it was unconstitutional.
Questions for the opponents of the bill? All right, seeing no questions for the opponents of the bill, that concludes the hearing on SJ1, our first and perhaps last joint resolution. Thank you to the sponsor, thank you to the proponents, and thank you to the opponents. Senator McKay will now move on to your bill, Senate Bill 602.
If it's okay with you, Mr. Chair, okay to bring up my panel? Here they come. Make sure it's here. Okay. Well, Mr. Chair, Mr. Vice Chair, members of the greatest committee in the Senate. That's how we roll. That's just how we roll here. I am proud to endorse Senate Bill 602. This bill will immediately begin the process of expungement for certain and eligible criminal charges as soon as the offender begins their sentence. It does not apply to the violent criminal offenses. This will not remove the state's attorneys from the process. Rather, the state's attorneys will continue to review these automatic expungement cases and raise objections that will stop the process and thus not allow it to be expunged. You're probably wondering why I am here and I am the lead sponsor of this bill. I've always been and will always be a second chance guy. In my employment, I give those who have been formerly incarcerated the opportunity to work in an environment that does not judge them on what has happened in the past, but actually values who they are and what they can add to my organization. I'm somebody who has an apartment complex that 75% of the people who live with me in that apartment complex have been second chance people. Because after they've served their time, after they have, for all intensive purposes, paid back to society, we should not, and I repeat, not hold housing against somebody because of what they've done in the past. So I'm a firm believer. Now, this particular Clean Slate Act of 2024 is a bipartisan, balanced approach. It has been passed in 12 states, including Pennsylvania, Utah, New Jersey, Michigan, Connecticut, Delaware, Virginia, Oklahoma, Colorado, California, Minnesota, and New York. I tend to believe it is the right balance for what we have started here in Maryland, and it will allow that these people, when they have served their time, they will not have to wait for expungement, but it will be ready for when they release to be able to get a job in my cleaners or live in my house without having fear of not being able to provide for themselves or being reunited with their family. So I urge a favorable report for Senate Bill 602, and I will turn it over to my panel. And to be perfectly honest, you guys are the experts. As I've said for many, many pieces of legislation in the Maryland General Assembly, I am the eye candy. So if you don't compete with me on eye candiness, and I know what you were thinking, okay? Whoever wants to go first, I'll just allow them, but just remember, you can't knock the king down, okay? Yes, sir.
God bless Senator McKay.
Well, I haven't been called eye candy in a while, but I will go next. So can't compete with the senator. Christopher Dews, representing the Center for Urban Families. We're a workforce development organization out in West Baltimore, primarily operating out of District 40, and we support the Clean Slate Initiative to just kind of automate the expungement process. We like this bill. We think it's going to be very effective. We know there's a lot of technical aspects of it, but we trust the members of the committee to be able to work that out. And I know there are members of this panel who will speak in detail about proper implementation. Just want to talk about this from the workforce development perspective. There's a lot of, let me just be blunt, Center for Urban Families does a lot of partnerships with, let's say, Office of the Public Defender, Maryland Legal Aid, Maryland Volunteer Lawyer Service, all of whom will either do expungements for us or host expungement clinics. Happens all throughout the city, all throughout the state of Maryland. And with the Clean Slate Initiative, a lot of those expungement clinics and the work that goes behind them will be automated. So a lot of that work will come off of these different forces. And this is important for us because I think the data shows that only 2% of the individuals that are eligible for expungement actually take advantage of the expungement, primarily because they just don't know that our courts are backlogged when it comes to having their records expunged. From my understanding, the bill, as I've read it, does not actually add anything to the expungement statute. So we're just talking about charges that are already eligible for expungement. And I just think it's a nice addition to what you guys have already accomplished with the Justice Reinvestment Act, with the Redeem Act of last year. It just simplifies the process and makes it easier for individuals to get their records expunged. And with that, I urge a favorable report. Thank you.
I'm glad to go after someone else so tall. So I can, Chairman Smith, Vice Chair Waldstreicher, and members of the committee, my name is Daniel Okonkwo, and I'm a corporate responsibility market strategy lead for the Mid-Atlantic at JPMorgan Chase. Thank you for the opportunity today to provide a statement in support of Senate Bill 602. 1 in 3 Americans, roughly 80 million people, face barriers to employment due to an arrest or a conviction record. JPMorgan Chase is committed to addressing some of these barriers and giving people across the country a second chance. In 2022, we hired more than 4,600 people with criminal records whose history had no bearing on the requirements of the job they were seeking. That's about 10% of our workforce in the United States. We believe that business has a role to help more people share in the benefits of economic growth. As a founding member of the Second Chance Business Coalition, JPMorgan Chase is also working with nearly 50 large companies across multiple industries who are committed to developing best practices and tools for employers to deploy second chance hiring and advancement strategies within their firms. But to achieve systemic change, we need improved public policy, including common sense measures like the clean slate automatic record clearing for eligible offenses. In Maryland, more than 400,000 people are eligible to have their records cleared, but very few pursue the complex, time-consuming, and costly process. To provide relief in this area in the communities we serve, JP Chase's legal pro bono team hosts expungement clinics along with community partners. JP Chase has a presence in 50 states. We're always looking for top talent and looking to lower barriers to employment. For example, we recently launched a virtual call center in Baltimore, which allows our employees to work from home and removes some of the barriers to in-person employment. These new team members are among the more than 500 employees in Maryland, serving more than 1.6 million consumer and business customers. I'll conclude right now. By reducing barriers to employment for those with criminal records, clean slate legislation can play an important role in strengthening our families, communities, and the economy. We urge a favorable report and thank you for the committee's consideration of this legislation.
Thank you, Mr. Chairman and members of the committee. My name is Dr. Laura Chavez, and I am the Director of Research and Data at the Clean Slate Initiative, a national nonprofit whose mission is to work alongside states to streamline the record clearing process and ensure it happens automatically. I'm here on behalf of the Clean Slate Initiative to express our strong support for SB 602, which aims to rectify the impact of past records on individuals and communities. As of 2019, around 1 million adults in Maryland, or 22% of the adult population, have some form of a record. That presents significant barriers to employment, housing, education, and social reintegration. Clean slate legislation has proven to be an effective tool in addressing these challenges. Again, in Maryland, only 2% of people with convictions eligible for clearance under the current system get relief. It would take 86 years to clear all the eligible convictions under the current system, which is costly and difficult for impacted individuals to navigate. Clean Slate could provide full record clearance to over 410,000 adults in Maryland. 12 states have enacted Clean Slate laws, including our neighbors Delaware, Virginia, and Pennsylvania, and the positive impact on individuals and communities has been substantial. Under the current system, the estimated aggregate annual earnings loss associated with clearable convictions is $1.5 billion of taxable income. In addition, Clean Slate can reduce racial disparities in Maryland, reducing the Black-white disparity in conviction records by 1/3. The Clean Slate Initiative applauds the proposed creation of a state-initiated process to expunge records of arrests and convictions so that Maryland can lead in the pursuit of fairness and justice. The proposed timeline starting from January 1, 2027 to begin implementation aligns with timelines of other states and allows for a smooth transition to a more equitable system. We urge the committee's favorable report. Thank you, and I'm happy to answer any questions.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. For the record, my name is Evan Richards. I'm the Senior Policy and Political Strategist with the Maryland Bankers Association. Now, I'll be brief. We're here in strong support of Senate Bill 602. We're proud of the work that our partners at JP Chase are doing, not only in this, in this arena, but in investing across the state. You may have seen additional branches open up, but I know their investment is continuing. So I want to stand here publicly and thank you for that. If you were to ask any bank president and CEO across the state what their biggest obstacle is right now, it's attracting and retaining talent. So they're looking for that increased talent pool. And by implementing the automatic expungement process laid out in Senate Bill 602, you're providing that, not just for banks, but for all businesses. You're providing that extra opportunity for, for people who have paid their debts to society to re-enter the workforce and to obtain high-paying jobs, such as ones available in the banking industry. With that, you have our written testimony. We urge a favorable report. Thank you so much.
Thank you, Mr. Chairman, and thank you, Senator McKay, for bringing this bill. I had never heard of this before, but I'm new to the committee, but it's my second year. But I do have a couple of sort of technical questions, if you will. Senator McKay, you may have said this, but I assume this does not change any of the eligibility. It's just trying to streamline it, and rather than keep the onus on the individual to begin the process, take it from a position of opt-in, not opt-out. You know, in other words, you start the process whether they've initiated it or not. It's just an automatic process. Is that the idea? Oh, either way,
my
Senator.
apologies.
Well, I was, because Senator McKay, I think it was in your testimony.
You're 100% correct. We are not changing putting any new expungements in. We're not messing with any of that. The whole concept is that process starts at the beginning, so that once they've served their time, all this paperwork, for all intents and purposes, is up to date and current. And so that's all we're doing, is trying to make it more of a fast track, a pathway to prosperity for them.
I assume whatever the state's attorneys or prosecuting attorneys normally do, if it was initiated on an individual, they still have all the rights
Yes.
and opportunities
Yes.
to object if they think it's not proper.
Yes, the regular process is still there. And also just want to quickly highlight the manual process still exists as well.
Okay.
Just just in case there's some confusion, I know there's different waiting periods for the automated system versus the manual process. So this is just layering on top of what we already have.
And then you may be aware, I know Senator West, we're just about to, I hope, pass a bill to extend I don't know if we call it a work group or a commission to basically try to rewrite our criminal code because of how much it is an outlier. And I'll give you the example I will give you is second-degree assault, which in almost every other state is a felony, but in Maryland, first of all, it's a crime of violence, and two, it has 10 years. So that would be the kind of crime that, might get not properly addressed in this bill if we don't try to improve the way we categorize crimes in this state anyway. So I caution you on that. I don't think other states are up against that particular problem, that we have a very odd way we categorize felonies, misdemeanors, crimes of violence or not violence. So sure, throw that out there. It could be worked through, but it is an onerous task to see if we have outlier crimes that might not fit in here. The other question I have is, this committee has debated and DUIs and DWIs, right? We had this lifetime, it's on your record. And we have been working through the idea, I don't know if we passed it or not, but we're working through the idea of potentially allowing for expungements, because you get sometimes PBJs and the like. But we were very mindful about never keeping that away from the courts and the prosecutors, because of, our values and our policy, which is that we do not want drunk drivers on the road, and we certainly don't want to be blind to repeated conduct. So I could ask you a question. So how would DWIs and DUIs be dealt with under here?
So first of all, there are definitely others that can answer that question probably a little bit better than I can, but.
Or you can get back to me, but I'm just throwing out some things that rather than make the hearing longer.
So
we can
I
get back
understand.
to
And so I just want to say, just to be clear, everything that will be under 10-110, which if
I don't know them by the numbers.
Oh, they're totally fine. Basically, when it comes to the DUI piece of legislation, I know that's going to add to 10-110 the eligibility, and then then adds a separate waiting period. Because Clean Slate currently does not consider that.
Yes.
It's not. So that's something we can definitely get back to on.
And I would say that we'd want to, if you all would be amenable, working with the prosecutors, because they may come back and say, look, there's public policy reasons why, if we even go down this route, we still want courts. And the prosecutors and law enforcement in certain circumstances to have access to this, so it can, cannot be completely wiped away.
All I was going to say was there's a prosecutorial objection that is already listed in the bill as well.
Oh, I get that, but I feel like there's some policy that is, even though it's a model bill, you might have to adjust it for Maryland. And then last thing, the judiciary has an extensive opposition, and not to the spirit, I think, more in terms of operationally, paperwork wise. how did other states, if this is model legislation, how did other states deal with, you know, the massive amount of proceedings that would then be sent over to the court system, and what's the fiscal impact?
And that is an excellent question
Yeah,
for another panelist. If you
okay.
want to speak to that, yes, absolutely.
I was trying to see.
Okay.
Yeah, I'm not sure it says 5.2 million, but I certainly want to hear from the judiciary on that.
Yeah, so I can say that the bill was designed with feasible implementation in mind.
Okay.
Only requiring readily available data and processes that shouldn't require digging through storage cabinets or rooms for paper records. It's all digitized, and that's going to ease implementation, and that's how it works in other states. It's also going to be easy for the government agencies that are going to be working to deliver the relief, where the bill specifies that only digital records are subject to the automated expungement. And so that's going to be a benefit. And the real ultimate goal is to prevent eligible records from showing up in background checks so that people can have greater access to second chances. It's not going to require an overly burdensome implementation process, and we've found that to be true in other states as well.
Well, thank you very much for that. I would suggest that you work with the judiciary if we were to proceed, because I take their comments very seriously. And the only other thing I wanted to ask and follow up, because I thank you for your indulgence, really, I appreciate it. You know, very interesting that you mentioned that only 2%, I think, of eligible currently in Maryland, only 2% of eligible clean slate type people actually go through the process. So my question to follow up is that because there's not enough notice and you know, education to the people, and or do a fair number of these get rejected because of objections by the state's attorney? And I imagine you cannot possibly know the answers to that, so you should follow up with me. Is that fair?
It's absolutely
Okay,
fair.
thank you.
I will just say the only piece I was just going to say is that I am definitely aware that because expungement laws do change all the time,
right,
that there's a lot of individuals who just don't know. So this would actually assist with that process as well. But
very good. Thank you, Mr. Chairman.
Awesome.
Thank you, Mr. Chairman. I think, Mr. Dews, you're probably best positioned to answer this question. So as you know, I'm a co-sponsor of the bill, deeply empathetic, and you and I have worked together over years on expungement issues. So this changes the expungement trigger period from the end of the sentence to the conviction. And I worry that we may have accidentally created kind of a time paradox here, so that someone could be incarcerated and have the offense for which they are incarcerated expunged during the term of the incarceration. And so I just wanted to kind of bring that to your attention.
Yep.
And whether that went through your head, and if not, you know, no one can think of everything, but that's going to be something perhaps we need to address if you want to talk about that.
Yeah, first of all, that is an excellent point. The reason why, from my understanding, and other members, of course, can talk to this issue, that the automated system was designed with a separate waiting period time was because of I know there are other members that can definitely speak to this better than I can, that when it comes to automation, that the primary issue is that either the data wasn't available, there was some specific tick that would disallow it from being done with regards to the waiting periods, as we discussed in the legislation from last year. I do know that not the committee members, that we are open to finding a way to fix that. What we were informed as, or at least what I've seen was best practices in other states, was just setting a different time period from the initiation of when they are incarcerated. So that's to be honest, relatively new concept when it comes to expungements for Maryland. And I think we are open to having that conversation. Absolutely. Yeah.
Thank you, Mr. Chair. So I guess my first question, thank you for bringing this bill to the sponsor. We've been working on expungement issues for some years now, and the idea of automatic expungement certainly makes sense. But there are some logistical issues involved. So Mr. Dews, you've read the fiscal note. It's expensive. I think frankly, it's money well spent to get these clouds dispelled from people's ability to live successful lives. But do you think the fiscal note is correct in its estimate? I think it said it was $5.2 million a year in order to $5.2 million going up to well, about 5.2 million per year to handle this.
So
Is
I'll to be direct, I don't think so. In the same way, on other expungement bills, that there's always a conversation it's going to cost millions and millions of dollars. Because this is a novel concept for the state of Maryland, again, I will pass this over to individuals from other states who can speak to what other states and their numbers. But I will say, I think 5.2 million is a lot, very similar to what we saw with the unirule conversation and other issues as well. But I will pass it over to.
Maybe I could ask the representative of
By
the
all means.
judiciary whether or not she also feels the 5.2 million is in the ballpark of what it's going to cost.
I apologize. I hadn't had a chance to read the fiscal note. I understand that it was came out today, right?
Yes,
Yes.
I just saw it.
So I apologize for that. And I'd like to oh, okay. I see. Okay, well, I'd like to get back to you if that's okay on what it costs in other states, but I will say that data upgrades are oftentimes needed, not just for this bill, but in general. And so that can be a benefit.
Okay, as I understand it, the judiciary is rapidly digitizing its records. So as time passes, you're going to be more and more able to accomplish these expungements without deploying huge numbers of people, rather instead instituting programs on your computers to flag these situations and take care of them that way.
Yes, that's right. And the implementation timeline set in the bill is January 1, 2027. So that allows for enough time to put the administrative processes in place.
To get ready. Okay, thanks. And
Thank
finally, Mr. Dews, one last question, and that is the main objections appear to be that the bill does two things. It provides for automatic expungement, but it also allows it says expungement can occur even if the offender has disregarded their sentence and the conditions of probation. Do you think it would be possible to separate out the two and, for example, take the language out of the bill that says you can get your offense expunged even if you haven't completed your probation successfully, and take that away and leave the body of the bill, which provides for automatic expungement?
So, and I know we've had this conversation on other issues. The issue with, and I think it was the Abhishek case, that language was put in here because unfortunately, when it comes to automation, because of the nature of violations, the automated system will not work properly if the violations concern is not addressed. So we, again, are open to the committee's jurisdiction on how to make that work. Trying to find if there's anything else I probably should highlight. I just know that if a person has a violation, that would greatly hamper how the automated process works and how it has worked in other states. So that's the reason why that language was in there.
Right,
if it were to be removed, I do think there would be issues with proper implementation.
Well, let me follow up on that.
By all means.
Just briefly. So even though the records of the courts are being digitized, you still would have to have some human being who would review the list of people who are qualified for automatic expungement and double check to make sure that all the conditions had been met. Wouldn't that be correct?
That would be
so
correct.
If someone had not fully complied with the conditions of their parole or their release or their probation, that could be flagged by the courts and the record could be pulled, so it would not be put in the process of automatic expungement.
Yeah,
Would you agree with that?
I want to say that that sounds absolutely correct. My issue is that I just know we've had long, extensive conversations off talking about this issue, and there was a very specific reason, which I apologize that I can't speak to, that language had to be in there for proper implementation. I think you're absolutely correct in everything that you said. I think that there's another element that I am just not fully aware of in this moment that would have caused that to not be the case. And I'm sure there's another panel that can speak to that.
Okay,
I do
well,
apologize.
maybe I could once again ask this question of the representative of the state judiciary who's here. If you could go back to the podium. Sorry, this is like a jumping jacks, up and down, up and down, up and down. So if the committee chose to take out of the bill the provisions which provided that automatic expungement would occur even if the paroled or pardoned prisoner has not complied with the conditions of the pardon, would the judiciary have the resources once the machinery pulled out the names of the people who were eligible for expungement? Would you all have the resources to separate out from that list the former prisoners who had not complied with the conditions of their parole and therefore were not eligible for automatic expungement?
It's a good question, and it depends on how it's coded in the data set. And as long as there's a code that indicates that case has been flagged for not complying, then it can be pulled out automatically.
Okay,
And
great.
yeah.
Thanks very much.
So a question for just Mr. Okongo. Thanks for, Andrew Rostergan has his like book deal forum up in New York, and political leaders from across the country come in and captains of industry came in. So Jamie Dimon came in and talked about a lot of these initiatives and then talked a little bit about what you all are doing in Baltimore City and then in Anacostia for kind of second chance and investing in community. I just wonder if we might continue that conversation and we have a number of folks that are, Bankers Association as well, that are here in support of this bill. I wonder if we could just carry on a conversation offline of some other opportunities that we could pursue through legislation to partner with you all, because I think you guys are doing some pretty cool, innovative work. And as the senator said, I think it's a really good opportunity for us to, provide some opportunities for people to get back into the workforce. So.
Sure. And I would just respond by saying we welcome that conversation. This is an important issue that we've taken the same position on in many of the states that were mentioned where this type of legislation has been passed. So we're open to that conversation.
Excellent. Yeah, we'll reach out. This is good stuff.
Perfect. Thank you.
Excellent. All right. Further questions? All right. Thank you all very much. All right. So we have a couple more panelists signed up in favor of this bill. Laura Chafee, there you go. Evan Richards. Oh, that's you. And E. Flannery Gallagher in the back. Do you have anyone else? Oh, Ms. Kess from the end of the, you're right, sitting right in front. Okay, and then we'll have one panelist join us virtually, and then we'll take questions.
Thank you. Good afternoon. My name is Laura Chafee, and I'm the legal director of Shore Legal Access, formerly known as Midshore Pro Bono. Shore Legal Access is a civil legal service provider located on the Eastern Shore. Each year, we help over 3,000 people with limited means access legal services. Shore Legal Access supports Senate Bill 602, and while I cannot speak for all prosecutors, as a former prosecutor myself of 7 years in Dorchester County, I personally support this bill. This bill would clean records for many Marylanders, allowing them to access employment, housing, and education. The positive impact of expungement on our clients is huge. Clients with clean records obtain better jobs and make more money. This is the top reason why people seek expungements through us. Additionally, there are more housing opportunities for those with clean records, with particularly, this is essential with the lack of affordable housing. We see this firsthand working with tenants who are facing eviction. Even educational opportunities are more available to those with clean records. We often see clients seek expungement because they are trying to get into college or trade school. The Clean Slate Act would eliminate the burden of navigating the complex expungement process without an attorney and funds for the filing fees. This process is difficult. The process can even be stressful for attorneys at times. Automating the expungement process, eligible candidates for expungement may forego this complicated process altogether. Shore Legal Access has been providing expungement services for many years. We currently host expungement clinics, and since April of 2023, we've assisted 281 clients obtain expungements. Service legal providers would be also benefited by this bill. Instead of providing expungements, we can focus our work on other issues facing low-income Marylanders, such as housing, family law, and consumer debt matters. For these reasons, we urge a favorable report on Bill 602. Thank you.
Good afternoon. My name is Flannery Gallagher, and I'm a legal fellow at the University of Baltimore School of Law's Center for Criminal Justice Reform. The center is dedicated to supporting community-driven efforts to improve public safety and to address the harm and inequities in our criminal legal system. We are grateful for this opportunity to testify in support of Senate Bill 602. Maryland has the opportunity to join the growing number of states that are passing clean slate legislation. Since 2018, more than 20 states have enacted some form of automatic expungement. I want to draw the committee's attention to a first of its kind empirical study focused on Michigan's then petition-based expungement landscape that was published in the Harvard Law Review in 2020. Researchers there made 3 key findings. First, people who obtained expungements virtually all stayed crime-free thereafter. Second, expungement appears to have substantially expanded recipients' job opportunities. Within a year after expungement, average wages increased by about 23% after controlling for the same individuals' prior wage trends. Third, under petition-based systems, very few people actually obtain expungement. But even among those who did qualify under the then operative rules, researchers found that only 6.5% received expungements within 5 years of becoming eligible. Michigan's low uptake rates are consistent with academic findings across the country. Another national analysis found estimated uptake rates across the states range from 0.2% to 11% for expungement of conviction records. Without Senate Bill 602, the broad public policy benefits of expungement will not be fully realized. Senate Bill 602 will ensure that people are no longer defined by their criminal records, have the opportunity to contribute to their communities, and get a fair chance to work, seek an education, and achieve their full potential. Thank you all for the opportunity to testify in support of this important bill. We urge a favorable report.
Good afternoon, Chair, members of the committee. My name is Nishana Kess. I'm the Executive Director of the Maryland NAACP. As the NAACP, we stand in strong support of the Clean Slate Act. One of the most crucial aspects of this bill is that it will streamline and expedite the expungement process. As you can imagine, this is particularly impactful for communities of color who are disproportionately impacted by over-policing and harsh sentencing practices. Bill 602 recognizes the need for individuals to have a fair chance at rebuilding their lives after involvement with the criminal justice system. For far too long, people of color have been burdened with the stigma of past convictions, which can limit employment opportunities through background checks, housing options, as many housing opportunities, especially affordable housing, base housing determinations on criminal records, access to education, as many educational institutions and training programs require applicants to disclose criminal history. Automatic expungement will positively impact one's financial stability and mental health. As an attorney who has engaged in expungement clinics, I have seen many who have been eligible for an expungement for many years, but failed to file simply because they were unaware of their right to the expungement. 602 represents a critical opportunity and much needed relief to communities of color and marginalized individuals who have been disproportionately impacted by the criminal justice system. As the NAACP, we urge a favorable report on this bill.
All right, thank you very much. We're going to hear from the virtual panelists, and then we'll take questions. Welcome, Ms. Towns.
Thank you. Thank you so much. Good afternoon, Honorable Chair, Vice Chair, and members of the Judicial Proceedings Committee. I am Lori James Towns, and I'm before you today as the Executive Director of the National Association for Public Defense and a lifelong Maryland resident. I spent my entire professional career involved in criminal justice reform and public defense. This legislation represents a significant stride towards justice and redemption, underpinned by our shared belief in second chances and rehabilitation. The Clean Slate Act moves us closer to empowering returning citizens with the mechanism to petition for automated expungement of certain eligible offenses. Allow me to expound on the impact an automated expungement could have. Returning citizens or directly impacted individuals are empowered through increased employment opportunities because their criminal record is often the biggest hurdle in securing gainful employment. Rehabilitated citizens gain access to housing to create enhanced stability and growth for their families. An automated record expungement process widens the gates for those who seek self-improvement and economic mobility through higher education and training. When certain offenses are wiped clean from a person's record, it dismantles the barriers to community engagement, their ability to support their family, and foster societal inclusion. This bill embodies the values of forgiveness, growth, and equity. It aligns closely with what we stand for at NAPD, ensuring a fair and just legal system for all, particularly for those willing to make amends and move forward with their lives. Members of the committee, I urge you to contemplate the lifelong benefits of this bill, and it will usher in not only for individuals, but for everyone seeking for what society at large, who thrives for, when each of us and our members are given the opportunity for dignity and opportunity. Thank you so much.
Where's our sponsor? Because he might want to answer this question, because I forgot. You all can weigh in if you know this. I think somebody may have said something about any data on people reoffending after expungement. And if you could get me that, hopefully that's low. And I thought maybe you even touched on it. And then I looked this up myself as well, but any information about in any instances where it's already, of the law and the process, whether there were cases where the judiciary, law enforcement, or prosecutors were a bit blinded and not able to, fully do their jobs because they did not know about someone's criminal history. So those are just some thoughts I had about getting some data. Hopefully it'll be data that helps you, but at least I'd like to know what it is, good, bad, or indifferent.
So I don't have any data, but I can say that there have been many people who are looking for expungement whose cases have been 20 years ago. Right. And they were eligible for expungement for a very long time.
Right.
And they have had no history after that. And that's one of the requirements under the expungement law, right? Is that they don't reoffend after a certain period of time.
I think, right, for felonies, maybe.
Correct.
I'm trying to get information. So if I am questioned in my district, which is clearly not liberal, it's also not wildly conservative, but they're a little center right, and they ask tough questions. It's sort of a show me county, like, show me why you did this. Why was this a good idea? And did you think through all this stuff? So I'll ask the sponsor also to ask the first panel, which might have a little more data than you do, but I meant to ask them and thought maybe you could address it, but thank you.
Yeah, the other thing I'll say is this doesn't substantially change any of the expungement laws that currently exist.
Right.
So it's simply changing the process in which it can be done. So most of it is more processing than any substantive type of changes.
I get that.
Yeah.
And I'm with you. I just would, if there's anything out there one way or the other, if it doesn't exist, that's fine too. I don't want to get blindsided by someone asking me something that I wasn't aware of. So thank you very much. Thank you, Mr. Chairman.
All right, thank you all very much. And the sponsor of the bill, he's a hardworking man. He's in another committee right now, testifying on another bill. So
Well, I'm sure he's charming them with his candy cell. Sugar baby. She's a sugar. He's a honey.
Oh man. All right, well that'll conclude the hearing for Senate Bill 602. And now I'm going to Senator Folden with Senate Bill 606.
What is this? What is that?
Six oh six. Mr. Chair, Vice Chair, members of the committee, esteemed colleagues. For the record, William Folden, Senator for District 4, here on Senate Bill 606. And this bill relates to an order to show cause and for the purposes of authorizing a police officer who is denied a certain right to apply to the circuit court at a certain time for an order that directs law enforcement to show cause why their specific rights should not be granted. It's about a process. It's about allowing them to be a part of this process, to be able to advocate for themselves and show cause for any actions being taken against them. So with that, I would ask for a favorable report on 606, and I'll turn it over to my panel. Thank you.
Good afternoon, Michael Davey, General Counsel to the Maryland State Fraternal Order of Police, and we're requesting a favorable report on Senate Bill 606. The passage of this bill will allow a law enforcement officer who's been administratively charged either by the law enforcement agency or administrative charging committee the ability to go to circuit court for an order that directs the law enforcement agency to show cause why a right under the Maryland Police Accountability Act was not granted. This bill will allow the law enforcement officer to file a petition for show cause in the county in which the law enforcement officer was employed prior to the start of the hearing. This action would require the law enforcement agent to explain to the court why the right or provision under the Maryland Police Accountability Act was not granted or followed. The purpose of this bill is basically judicial economy. If the circuit court judge agrees that the law enforcement officer's right or the provisions of the Maryland Police Accountability Act were not followed, the judge will have the ability to order the appropriate remedy. The remedy will likely cause, or as it pertains to judicial remedies, or judicial economies, basically what it would do, it was allow the court to intercede and possibly not have the administrative trial board have to occur twice. There's nothing in this bill that will require the agency to not go forward with the trial board. There is some case law from the former Law Enforcement Officers Bill of Rights, the Hayden case, that basically says departments can go forward, but they go forward at their own risk, knowing that if the agency does not succeed in the show cause, they may have to do the hearing board again. And that's the reason for the judicial economy. We're just trying to get out in front of this before we waste a lot of time and money on behalf of the department. Thank you. We request a favorable passage of Senate Bill 606, and I'd stand for any questions.
Good afternoon, Mr. Chair, Mr. Vice Chair. My name is Jerome Spencer. I'm here on behalf of the Maryland Chiefs and Sheriffs Associations. We're here to provide some information on this bill, Senate Bill 606. And the information comes down to basically 3 points to make you aware of. Point number one, show cause orders cause delay. By definition, they do. It requires whatever's going on with the disciplinary process to stop and wait for the circuit court to make a decision. It requires getting a hearing before the circuit court judge. It involves appeals that can take up to 2 or 3 years after. When you go back to the cases under the LOBR, there'd be year-long delays. Now, Ms. Davey is absolutely correct. The agency could still go forward disciplinary matter, but as the case law also told us under the LOBR, they did so at their own risk. And certainly I would not advise my sheriff's office to go forward on disciplinary matter if there's show cause pending. Number two, the way the bill is drafted, it says the officer can make a show cause order and the law enforcement agency has to respond to that. And yet a good chunk of the police disciplinary process now does not involve the agency. It involves administrative charging committee. It might involve a PAB. It might involve a county not selecting a trial board member. It might involve a PAB not selecting their trial board member. There are a lot of things in the process outside the scope of the agency, and this bill required an agency to respond to things the agency has no control over. And finally, number three, the PAA is still new. We're working through it. We've just had our first trial boards. My agency was the first to do trial boards under the PAA. We did them in November. We're beginning to see the trial boards. There is an appeal process to that. Issues involving the PAA and how it is working or not working can be resolved in appeal at the circuit court level if an officer found engaged misconduct found a trial board and disputes that finding. So with that, I'm prepared to answer questions you might have on this. Oh, I forgot to add the reason why we're here for information only. To begin with this, clearly the chief sheriffs do support due process of the officers. We recognize the PA presents challenges that we all are working our way through, and it's not about us, the chief sheriffs, denying due process officers, about making sure we understand what we're getting into if this bill is passed.
Excellent. Thank you very much. Questions from the committee? All right, with that, that'll end the testimony for the proponents bill. Thank you. We'll now switch over to the opposition panel. We have Mr. Roca, and then joining us virtually is Ms. Levy. Is she in the room? Okay, great. All right, Ms. Levy, we're gonna have Mr. Roca go first. He's in person, and then we'll switch over to you.
Mr. Chairman, members of the committee, my name is David Roca. I'm a staff attorney at the ACLU of Maryland. Appreciate your time today. We urge an unfavorable report on this bill for the basic reason that it is bringing back one of the truly bad provisions of the LEOBR, which this committee and the legislature appropriately and rightly jettisoned when the LEOBR was largely repealed in 2021. As to this interlocutory appeal process that it would seek to reauthorize, Maryland courts have repeatedly noted what an unusual process it is. There's quotes from those multiple decisions in my written testimony. I won't repeat them here, but in short, allowing an interlocutory appeal rather than treating officers like any other employee subject to a disciplinary process and requiring them to raise their objections before the administrative adjudicatory body and then appealing them if they think a mistake was made, I think is seriously misguided. And with that, I will conclude my testimony.
All right, thank you very much. Hear from Ms. Levy.
Thank you, Senator. This is Debbie Levy from the Maryland Office of the Public Defender, and we also urge an unfavorable report for Senate Bill 606. I'm echoing the individual, I think, from the Maryland Chief and Sheriff's Association and also Mr. Roca from the ACLU. We think from a policy standpoint, this bill is an effort to chip away at the repeal of the Law Enforcement Officers' Bill of Rights that this body supported just a few short years ago. And from a procedural standpoint, we also don't think that this bill makes sense. We agree show causes cause delay. They create two parallel proceedings. It really defies notions of judicial economy and fairness. And most importantly, charges are now brought by the Administrative Charging Committee. So the order to show cause seems sort of purposeless at this point because they couldn't possibly hail in the ACC to the order to show cause hearing. And I really think that this is, or we think as a body, that this is just an effort to delay proceedings against law enforcement officers through the administrative proceeding. I think I looked at the testimony from last year, and the only example that was brought to the table last year was individuals who'd been charged with a felony and lost their pay and wanted some way to redress that. And I think that that's a circumstance that individuals across the state of Maryland who face criminal charges deal with on the regular and don't have the opportunity for an order to show cause. And so folks should be careful in charging decisions when they're bringing charges against officers for felonies, but this is not the right answer to address that problem. There's just really also no statistical need for this. And I see this as no more, we see this no more as a way to delay administrative proceedings and resurrect LEOBR. And on that, we would submit for an unfavorable report on Senate Bill 606.
Thank you very much. All right, question. We have Senator Fulton has a question.
Thank you, Mr. Chair. Sir, thank you for coming out and your words. I'm just curious. You brought up an interesting point about saying that other components or other employees across the state that, that they don't have this. So am I understanding that the ACLU is against due process for any employee, regardless of their occupation? Like if it weren't law enforcement and due process, this is a matter of being able to go and have the opportunity for a show cause when it is in violation of what the MPAA is already set to be. You're saying that due process shouldn't be afforded to police?
Senator Fulton, of course, I'm not saying that police are not entitled to due process. Police are entitled to due process just like any other public employee. The order to show cause process is most definitely not a requirement of due process. The point I was making is that other public employees, non-police officers who are subject to a disciplinary process do not have the order to show cause option available to them under the administrative procedure rules that apply to all other disciplinary processes.
Well, that's the uniqueness of this. So the administrative provisions, procedure rules that apply to other employees are wholly different than the ones that this body placed against law enforcement. There's a disciplinary process. There's the ACC, the PAB. There's multiple tiers to this. So I kind of find it interesting that the ACLU comes in and goes against a matter of due process,
But this is
solely
not-
against, solely against one class of employee and thereby citizen of the state. So I'm done. Thank you.
Well, you're characterizing this as somehow being a requirement of due process. It absolutely is not a requirement. Due process does not require an order to show cause process. That was a special right given to police officers under the old LEOBR. It is absolutely not required by the Constitution. Due process does not require an order to show cause process. All that due process requires is that officers have the opportunity to challenge the discipline being imposed upon them in the administrative hearing process, and they can then appeal that discipline to an appellate court, just like everybody else in every other context. That's why in our court system in general, we don't allow these kind of interlocutory appeals as a general matter. We do.
Further questions from the committee? All right, thank you very much. With that, that will conclude the hearing for Senate Bill 606. We'll now move on to Senate Bill 607. Hold on, I'm sorry, Senator, yep, sorry. I know it's a little unorthodox. No. I actually neglected to invite the opposition panel for the last bill up. And so I want to Senate Bill 602. I want to make sure that No, for the prior bill, for the Senator McKay's bill. Yeah, so that's on me. That's on me. Mr. Kroll, go ahead.
Thank you, Mr. Chair and members of the committee. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland and Executive Director of the Maryland State's Attorney Association, here in opposition to Senate Bill 602 and asking for an unfavorable report. I am in favor of second chances in certain particular crimes. I said to Senator West, I said to Senator McKay, and if Senator Hughes was here, I'd say to him, three people I constantly say it to. But this is not the vehicle or the bill to do it to or do it for. The reason I say this is it eliminates the word satisfactory. You should not be able to expunge any conviction unless you have satisfactorily completed your probation. It means your restitution is still open. It means you haven't done what the courts have said. Getting an expungement is not a right and not a privilege, but an earned right through law. And it should be that way. You should do so through successfully completing satisfactory probation. And if you have done that, you deserve to have that expungement. And it can be expanded. I'm in favor of certain crimes being, but not a crime of attempted murder, not a crime of attempted anything that could be a misdemeanor, not a crime of solicitation to commit murder, not an NCR that could be expunged for murder or for rape or something like that. So what I'm saying to the committee is this: there is room to expand. I'm willing to work with this committee to do so. Senator Wallstreicher, I compliment you for your expungement bill last year. It was a first step in many steps that we'll have this continuing conversation. But we can't have it for people who have not successfully and satisfactorily completed their probation. They do not deserve an expungement. There are other means that I will discuss at a later time offline of ways you can expunge your record, either by pardon or by good cause shown, that I would agree to on certain crimes. But if you're entitled to under the law, you've earned that right. But make sure you successfully complete satisfactorily your probation. And for that reason, we are opposed and in fact asking for an unfavorable report as to Senate Bill 602. I know I'm out of order. I know it's late, but I'm happy to answer any questions. But I will say again, I'm happy to work with this committee again to make sure people who deserve and earn the right to expungement get that right.
Good to see you, Mr. Cole. I don't know. No, were you not here during the hearing on the bill? Were you elsewhere on the campus?
I was elsewhere between the House and the Senate. It's been one of those busy days today.
Well, I want you to know that we absolutely asked them to work with the state's attorneys and the judiciary. We brought up numerous exceptions to bearing in mind the way Maryland has an odd criminal code in any event that needs a lot of fixing. I use second-degree assault as a good example of a misdemeanor that ought to be a felony. So there was almost everything you brought up, members of this committee brought up and said that, you know, those things all would have to be addressed, you know, rather than just wholesale adopt the bill as drafted. So I just wanted you to know that I didn't think you we're here because you might have said, I want to echo what you all brought up as opposed to bringing it up with all that was brought up.
I'm just saying to the committee is the following. Before an expunge bill is filed, come see me, talk to me about it. I'm welcoming it.
That's what we told the proponents of the bill. They have to work with the state's attorneys and the judiciary. We know that.
Saying yes.
Yes. Hey, this is a softball, Mr. Kroll. Just say thank you very
Thank
much.
you very much.
Okay. Yeah, it was a tough for you to say, huh?
All right. So with that, that concludes the hearing,
Thank you, Mr.
the
Chair, for
rehearing
hearing from me.
of Senate Bill 602. We'll now move on to Senator Folden with Senate Bill 607.
Do I have my panel? Okay to bring my panel in? Well, I wasn't talking about that. You're favorable, but where's the, I think. I believe I'm missing one witness on this. Oh, is he the one I'm missing?
Yeah.
Oh, okay. That's fine. Okay. Okay. Mr. Chairman, Mr. Vice Chair, esteemed colleagues, for the record, William Folden, Senator from District 4 in Frederick County. So before you is Senate Bill 607. And as a part of the MPAA, this body decided that all matters of discipline should be brought forward involving law enforcement from the lowest infraction to the highest infraction should go through the ACC as well as the PAB, Police Accountability Board, as well as the Administrative Charging Committee. The problem with that is that we have created a administrative backup of charges that should be and have been historically been able to be dismissed and adjudicated at a level of agreement between the employee for the infraction and the police executive, the chief or sheriff. So in doing that, summary punishment would be, this bill would allow that summary punishment would be maybe imposed for a minor violation of law enforcement agency rules and regulations if the facts constitute that the minor violation are not in dispute. And that summary punishment may not exceed a written reprimand. The FOP is going to ask, and we're amenable to any of the portion where the police officer agrees to the facts that constitute the minor violation are not in dispute and that they are accepting of the punishment. What this does simply is currently is something as simple as someone not wearing their hat in the court would result in a counseling. But because that would be considered a punitive measure, there's no way for the employee to say, yeah, I accept that. It has to be sent up in an investigation. It has to go forward to the ACC for their approval of said punishment when that level of infraction is clearly within the discipline matrix of the MPAA, which would allow the agency and should allow the agency to dismiss or to adjudicate said offense with a written counseling to be put in their personnel jacket or their annual review folder and be done. To not allow the employee. Now, the problem is that right now we have some people, some employees, because there is no opportunity for summary punishment, that will say, well, you know what? I don't know that I agree with that. Or not even to that effect. They're not even saying, I don't know if I agree with that. They're just saying, I want a trial board, just because they know what the maximum punishment they can get is on the trial board. And it backs up and costs the state and the local jurisdiction a significant amount of money by the time you build up the composition of said trial board with the court recorder and the members that are comprised of that review board. So I would ask for your favorable report on Senate Bill 607 to help allow police to be able to, on these very minor infractions, discipline their members and move forward without backing up the system, as well as creating an opportunity for both employee and employer to move past an incident that's not taking place over several months as we wait for the hearings to occur. And with that, I would ask for your favorable report. Thank you.
Good evening again, Mr. Chairman. My name is Jerome Spencer. I'm here on behalf of the Maryland Chiefs and Sheriffs Association, and we strongly support Senate Bill 607 as it is written. Senator Fulton made some amendments. We haven't seen those, so can't really talk about any amendments. But as written, Senate Bill 607 is a very important way to streamline and make the PAA more efficient. As Senator Fulton described to you, what happens now if there's a complaint of police misconduct involving a member of the public, that complaint, no matter how low level, no matter how minor that complaint is, must be investigated by the agency, which requires, at least for our agency, an internal affairs investigation on a very minor complaint, administrative charges committee review, and then if the officer doesn't like what the ACC has done, then it's a trial board, which involves scheduling a retired judge, an ALJ, a member of the public appointed by the PAB, an officer of equal rank, all for a minor offense that when all is said and done, the greatest punishment can be imposed under the statewide matrix is a written reprimand. If Senate Bill 607 is passed, it allows supervisors and chiefs and sheriffs to take quick, immediate, and efficient action involving misconduct of their employees at the low level. A common example we've seen in our county are courtesy complaints. The officer's rude to me. Here's the in-car camera. Yeah, chief, I was rude. Okay, can't do anything about it because we have to go to the ACC, wait to see what they say, and then get a trial board. This will allow a written reprimand to be imposed. It applies to courtesy violations. It applies to minor traffic accidents. It applies to failing to appear in court as well. We had to have a trial board and failing to appear in court when under the statewide matrix, we could do nothing. There's no discipline actually allowed under the matrix, but we had to go through the trial board for these very minor offenses. So we urge a favorable report in Senate Bill 607. Thank you.
Thanks. Before you leave the podium, just, do you have a sense of how much this is costing for, like, how much does this cost? You have any semblance of how much this costs?
So I can tell you that our county, I do not know how much, if anything, our PAB appointed member is being paid for the trial boards. I know the county had a contract with the Administrative Office of Courts for an ALJ. Ultimately, that became burdensome, so they found a retired judge who's gone through the required training. They pay him. They have a contract with him. They pay him per hour. I think we put up for his hotel because from Harford County, where he's from. He's doing a phenomenal job, as I understand it. So it's costing money and time. We also have, for us, we have an office for Prince George County coming down to offer equal rank. I don't think we're paying them. Prince George County may be paying them. I don't know, but we got to schedule that. So sometimes it is what it is. If it's a very serious offense, there should be a trial board. And if there's a contested issue, we should have the trial board. But for what ends up being a written reprimand, it's a great deal of work and effort and expense.
That's what I'm trying to highlight. Just for when the matrix only allows for a written reprimand, you know, how much is it costing the taxpayers of the state of Maryland to go through this process? Is it $5,000, $10,000? I mean, I'm just looking for a ballpark.
I don't think we're talking that much. Whatever the contract is with the retired judge, that's really between the county and the retired judge.
Yes.
And there may be a court report here, so we say that.
Yeah.
We record our proceedings, but
yeah,
it is per case, it's per hour. We try to combine cases. We try to do 2 in a day with our cases, minimize that cost, but it absolutely is a cost for a written reprimand. And I should add, we had at least one case where the incident occurred September 2022. The discipline is imposed December 2023 for a courtesy violation. 13 months for a courtesy violation, when it could have been, should have been, would have been handled really that day when we got the complaint from the citizen. So again, we're a favorable report. Thank you.
Good afternoon, Michael Davey, General Counsel to the Maryland State FOP. We originally signed up for this case as unfavorable, however, we've since signing up, we've had conversations with Senator Bolden, and I think we've come to an agreement on just one amendment to the bill. And that would be on page 1, line 17. Where it states B, summary punishment may be imposed for a minor violation of the law enforcement rules and regulations if the facts that constitute the minor violation are not in dispute. We would strike that period and simply add, and the officer agrees the facts are not in dispute and accepts the disciplinary action. And the reason why we would want that language is because without it, you don't have due process. And that's a major problem for obviously the FOP. So if we can incorporate that language as an amendment to this bill, we would be favorable. I've done two of the administrative cases myself. Both of them were with administrative law judges, one in Somerset County, one in Howard County. It's tough. I mean, I don't know what these jurisdictions pay the administrative law judge, but I can't imagine it's inexpensive. And just to give you an idea, right now in Baltimore City, even though this bill was passed in 2021, took effect in July of 2022, they don't have a process in place yet to have these hearings. We're backed up over 260 trial boards right now in Baltimore City because the department hasn't set a policy in place on how they're going to be done. I'm still weeding out the old LEOBR cases. But yeah, and if they're going to hire an administrative law judge, I will be long retired before we get through the bottom of that pile. So based on the amendment and the conversations we've had with the senator, with that amendment, we would request a favorable report on Senate Bill 607.
All right, seeing no further questions, thank you very much.
Thank you.
All right, I believe I've gotten everyone with this one. So with that, that'll conclude the hearing for Senate Bill 607. We'll now move on to Senate Bill 608. Senator Fulton.
Another very uncontroversial bill, Mr. Chairman. Esteemed colleagues, for the record, William Fulton, Senator for Legislative District 4. Here to present you matter SB 608 for the time limit for filing administrative charges with law enforcement. So the statute of limitations encourages, in some respects, forces a timely resolution of administrative charges, something that was the goal of the MPAA, to expedite the resolution of these charges. Statute of limitations are important for due process to ensure that an accused party can find and preserve evidence to use in their defense, as well as it will prevent unethical behavior by agencies as holding disciplinary actions over an officer's head indefinitely. In short, the way when the MPAA was crafted, it left out a very important part that says you can have indefinitely, there is no statute of limitations for going back and being able to enact administrative charges. What we have here is a bill before you that will set the administrative time limit for administrative filing of charges, as well as the amendment that would read that the time would start at the time that the law enforcement agency became aware. Part of the issue that we're having in law enforcement right now is with the MPAA and having the year and the day that as it's written from the incident, the trial board and like the FOP attorney spoke about, the trial boards are going beyond the year and a day. The agencies quite simply are losing the opportunity to hold their members accountable because there's such a backlog. So we need to be able to have a proper adjudication and facilitate a smoother process for a resolution. So with that, I would ask for your favorable report on SB 608, and I'll turn it over to my panel.
Good evening once again. My name is Jerome Spencer. I'm here on behalf of the Maryland Chiefs and Sheriffs Associations, and we fully support Senate Bill 608 with the amendment that Senator Fulton mentioned, clarifying about a year and a day from when the agency learns of an incident. But I want to emphasize something Senator Fulton didn't emphasize, which is the provision about criminal investigations. The way the PAA is now, if an officer has committed criminal behavior and ends up being acquitted by a jury, that officer cannot be disciplined. Let me say that again. If the officer is acquitted, he cannot be disciplined, because I guarantee you there's no criminal case against an officer that's going to be resolved in a year and a day. It's a year and a day to get through the ACC process. So Senate Bill 608 plugs that massive hole in the PAA. We're lucky we've not had the situation happen to us yet, but with Senate Bill 608, that can't happen. This makes sure that even if an officer is acquitted, there can still be an administrative review, still be an administrative investigation, still be reviewed by Administrative Charges Committee, it still be a trial board. These things can still happen, which it cannot happen now the way the PA is written. So we urge a favorable report in Senate Bill 608. Thank you.
Good afternoon, Mr. Chairman and members of the Judicial Proceedings Committee. My name is Sarah David. I'm Deputy State Prosecutor at the Maryland Office of the State Prosecutor. I know time is short, so I want to highlight some key issues about why our office is so supportive of this bill. First of all, there's a practicality element. Deconfliction is a normal part of the criminal law process, meaning that if an administrative agency is engaging investigation, that is stopped when there's a criminal investigation. Similarly, among general, criminal investigations, a federal investigation deconflicts with a state and so on. The fact that this bill will ensure that we can engage in that deconfliction process. Also, these investigations take time. I'd like to acknowledge Abby Tixay. She is the police misconduct prosecutor in my office. She is incredibly hardworking. She has tons of these cases. They take years to prosecute. And so we can't kind of be confined in this 1-year timeline. Also, in administrative proceedings against police officers, their statements can be compelled, which means that they do not have Fifth Amendment protections. That statement or anything derived from that statement cannot be used in a criminal investigation or prosecution. If that information is released, it taints our judges, it taints our juries, it taints our prosecutors, and it taints our witnesses, meaning that sometimes we cannot proceed with criminal charges. I'd also just want to note that the Office of the State Prosecutor recently created a unit to address official misconduct involving special victims. This is a very important area where we're not just dealing with a deconfliction process, but when you have internal investigations happening at the same time as criminal investigations, we're talking about re-victimization of individuals who are special victims by having to be interviewed by several agencies several times. And that can also introduce complexities to a criminal investigation. So we believe that this is important legislation for victims and to ensure justice throughout the state, and we urge a favorable report.
Questions from the committee? All right, seeing none, thank you both very much. Thanks. So that concludes the testimony for the proponents of the bill. We'll now hear from the opposition, Mr. Roca.
Thank you, Mr. Chairman, members of the committee. I want to be clear, our opposition here is to the bill in its current form. If amended, our opposition would be withdrawn. I want to also be clear that I think the better approach here would be to not have a statute of limitations as the LEOBR, when it was originally passed in 1974, did not. The statute of limitations was not added until 1988. And the reason for that is because it means that important cases end up getting dismissed for procedural reasons, not on the merits. That being said, if there is to be a statute of limitations, then we certainly agree that there needs to be an exception for criminal investigations to be conducted. We agree that administrative investigations need to be conducted in ways that don't interfere with criminal investigations, but we think that 3 amendments to this bill are necessary to make it a proper bill. One of them relates to something that I'm not sure I understood, Senator Folden, when you were speaking on the bill, as to when the trigger for the limitations period will be. As the bill is currently drafted, the trigger is the date of the offense. We think that's, so is this something we agree on?
Yes, it's the date of the agency made aware.
Well, the appropriate agency official, the language from the old LA. Okay, so that we agree on. The other 2 provisions that I think are important, this again may be just drafting error. As the bill is currently written, the tolling provision for cases, the tolling provision for criminal cases applies only to cases that are ACC cases, meaning cases that are not initiated by a civilian complaint. We think the subsection C of the statute would have to be amended to make the subsection E applicable, just like it is for the new subsection D, so that the tolling provision would apply to both kinds of cases. That's critically important. And finally, we think If there is to be a tolling provision at a minimum, it should at least replicate the tolling provision that was in the old LEOBR, which contained tolling not just for criminal cases, but also for excessive force cases, for reasons that I've outlined in greater detail in the written testimony. Thank you, Mr. Chairman.
Questions from the committee? All right, thank you very much.
Thank you.
All right, so that'll end the the hearing for Senate Bill 608. We'll now go to Senator Folden, Senate Bill 609.
Second. Want to welcome everybody back to Senator Folden's Legislative Day. Mr. Chairman, Mr. Vice Chair, esteemed colleagues, for the record, William Folden, Senator of Legislative District 4, Frederick County. Senate Bill 609, as before you, would add a protective element for the law enforcement, those men and women who are law enforcement officers, providing the blanket of security in which we all sleep under each day and are protecting the guardians of our well-being, the opportunity to be a protected class, much like we have created other classes of protected citizens. And really, this is an important bill in the idea that what we're seeing is a spike in aggression towards police. And this isn't, I'm not talking about even in the action in the course of their duties at the time that someone, resists arrest. That's not what this bill is about. This is about malicious, intentional actions against law enforcement professionals. And we're seeing that spike. And I can tell you from personal experience, I've had it happen to me where someone walked up my driveway and made it a point to make their disdain with my occupation as my marked police car sat in my cruiser, and they threw one of those big riprap rocks right through the back windshield of my cruiser. That happened to me on my own property. Now, what I will tell you is in Frederick County, there was another incident not too terribly long ago that involved a pipe bomb being set on the hood of a police officer's car as it was parked in front of his house. That bomb went off and destroyed the whole front end and window of his cruiser. That was nothing but a targeted attack, folks. Let's not make anything else other than what those are. Those examples are malicious, intentional acts as a point to show their disdain or hatred towards a certain group of people. And that's why we have these bills, these laws in place for these type of measures. When there's malicious, intentional acts against a certain body, a certain type, or certain people, So with that, I would ask for your favorable report on SB 609, and I'll turn it over to my pen. Thank you.
Good afternoon, Michael Davey, General Counsel to the Maryland State FOP, and we are requesting a favorable report on Senate Bill 609. The purpose of this bill is to add law enforcement officers to the list of groups that can be the victim of a hate crime. Over the past several years, law enforcement officers across the country have been targeted and/or ambushed by criminals simply because of their profession. According to the National Fraternal Order of Police, in 2023, there were 115 law enforcement officers victim of an ambush-style attack, not because they were doing anything other than being a police officer. We don't have to look any further in Maryland to December of 2021, when police officer Kiana Holly from the Baltimore Police Department was sitting in her patrol vehicle, not involved in any enforcement activity, when two suspects approached her vehicle, shot her several times, and killed her. There was nothing other than the fact that she was a police officer that attack occurred. The passage of Bill 609, Senate Bill 609, would send a strong message to criminals of the heightened penalties for killing or injuring a police officer simply because of their profession. But it would also send a very strong message of support to all the Maryland law enforcement officers that their community supports them and due to their very difficult job that they do day in and day out. The FOP strongly supports this bill and requests a favorable report on Senate Bill 609. Thank you.
Good afternoon. My name is Angelo Consoli. I'm the president of FOP 89, which is Prince George's County, and the second vice president for the state of Maryland FOP. I also urge your favorable vote on Senate Bill 609 for the same reasons that Mike has mentioned. That was half of my prepared stuff was there. But I'll go a little bit further. In 2016, we had one of our officers killed by friendly fire when three brothers showed up at District 3 station and started shooting randomly at officers and at civilians. In 2021, we had a detective in a homicide case, had suspects come up behind a building that he was in, mentioned some derogatory terms towards a police officer and fired into that building. Luckily, none of our officers were hurt. They chased the person down, recovered him and the handgun that he used to perpetrate it. We've had several members throughout the state of Maryland that have had their houses vandalized, their cars vandalized. Some of them, like from Prince George's County, that live out of the county, have had people, go to where their residences are and do the same thing. I think everyone knows the difference between just a regular assault on the police and an assault or a attack because of the occupation that we have. No one deserves the right, and it's a job that we take seriously, and we would hope that we send a message that we are going to be protected when people attack us solely because they want to attack the police officers. These attacks have gone on way too high, and also our property as well, and also goes to the Fraternal Order of Police buildings as well. Lodge 3, I think, has been vandalized at least twice in the past, and they also had their fallen hero memorial vandalized as well. So with that, I encourage a favorable vote on this bill. Thank you.
First to my good friend, last year, Senator, just remind me, I think you put in a bill regarding threats against first responders. Do you remember that? And somehow my staff decided to put it in this file as some relation. Did we pass that legislation, sir?
I don't think we did last year.
Did you refile it this year? It's okay if you didn't. I just wanted to know that. And then my other question is, can you speak to what other states are doing? I've been reading that other states are, I think at least one state has passed this particular legislation and others are taking a look at it, particularly in response to the escalating number of attacks that are clearly not dealing with police arresting people, but unprompted ambush attacks and attacks on their property, attacks on their vehicles, attacks on their headquarters, attacks on their homes. Can you speak to that?
Yeah, so I mean, obviously there's a unfortunate growing trend in light of recent national issues that we've seen an increase in these type of assaults. The short answer is I don't know all the states, but I'm more than happy to get that to you. I'll get that information, get that back to you. But I just want to also say that this isn't just about hate crimes on law enforcement. I can tell you that there's collateral damage here. My children, my kids are in school, and I can tell you that during all the difficulties that we were facing as a nation over the past several years, that my then 14-year-old daughter was the subject of much harassment for nothing that she ever did other than because her father was a police officer. I can tell you that
that's a bill for another year, sir.
I'm not asking for it, but I'm just saying, it's a
but
part of the job, right? And the way I take it. But when these attacks happen at your home, when there's a pipe bomb left on your car, that's no longer just an attack on the symbol that they're putting it on. Right. It's an attack on that person and their home, and it scares their children because now my children begged me at that time to get out of law enforcement, just to leave. And that's why you're seeing what we're seeing across the board is that we've continually villainized police. We've made them the subjects of much consternation and issues of conflict. Instead of understanding that, are there bad actors? Yep, there are. And should we hold them accountable? Absolutely. But these overwhelmingly people, I will put them as a class up with any class of citizen you have. And all the way up to, have we had bad presidents? Yep. Have we had bad senators, judges, clergy? Yes. What I'm saying is that this is a bill that's important because these men and women go out there every day and we're seeing the consequences of what we've done over the past 3.5 years now because we have low recruitment.
Yeah. We
have officers that because of the surge in the mid-90s that our current president was a huge advocate for in getting more law enforcement out on the street. Those men and women are able to retire now. and there's people not wanting to go back into the profession.
You know, two things. One, I hope you reach out to my county and make sure that my sheriffs and deputy sheriffs are aware of this, so if they would like to weigh in, and I would love it if.
I'd love to.
I don't know if you have time,
Yep.
you know, for that, but, also, I think you make a good point, and let me just ask it this way to any of you. Would law enforcement be aware of this bill if it's passed, and how, and would they view it as, us giving them some affirmation? And I ask this in the context of recruiting. There's absolutely a correlation between the last few years. Doesn't matter what side you're on, but just there's a correlation. Would this help with recruiting? I know we have work groups, but I honestly think this might be a faster route to signaling to some law enforcement.
So every police officer in the state is required to go through a minimum 18 hours of in-service training every year. And as a part of that training, many agencies, like the agency where I'm at, we're at like 32 hours minimum. Okay. A lot of that goes around first aid, but there's legal updates that come out, legal updates that this legislative body passes, because the officers have a certain amount of liability if they go out and start enforcing the old law when new laws have come forward. So we have to train them and educate them, make them aware of these changes. This is one of those types of changes that would be out there to be like, look, this legislative body has taken action to say, hey, we understand what's happening. We understand that this is wrong, and we appreciate you and are going to put this in place to say, look, if you maliciously and intentionally go out and attack an officer and simply by the walk of their life, that they're a guardian of our public, then it has, I believe, I mean, it has really good collateral. It has good consequences or no consequences.
I mean, look, in the last 8 years, police officers have simply been vilified. Everything they do, none of it is right, and they're basically the enemy. And police officers take that seriously. They go out every day. They try to do a good job. They try to do the best thing they can for their citizens that they're protecting. Sometimes things go bad, sometimes they don't, but they do the best they can. But they really see very little support from the community. So the support that the law enforcement have to get has to come from a body like this, showing the police officers that, look, we take what you do seriously. We know it's a dangerous job. We need you, and any support, as I stated in my testimony, that we as law enforcement officers can get, it would be appreciated. As the general counsel to the Maryland FOP, we do seminars, we have meetings quarterly, and these type of issues. I can tell you in April, at the end of this session, we spend a half a day just going over all the bills that were passed and not passed as it relates to law enforcement.
So they'll know either way.
Yes. And I can tell you, I'll be attending the Hartford County Law Enforcement Officers meeting Thursday night, and I will make sure that they are aware of this.
Please do. Thank you. Thank you.
And Senator James, real quick, as a matter of restorative justice, this body is constantly moving in the manner of restorative justice for people that are wrongdoers that have preyed upon our communities. Where's the restorative justice for our peacekeepers? And this bill is a tiny step in that right direction, and I think it's a meaningful step. So with that, that's how.
Thank you very much.
Yes, ma'am.
Okay, thank you.
Thank you very much.
All right, seeing no further questions, that'll conclude the testimony for the proponents of the bill.
Thank you.
Thank you. We have an opposition panel. So Deborah's, is she in the waiting room? And then Meredith, you want to come up?
First, you want her to go first?
I have, because I'm going to ask questions. And I'm
Good. All right. Thank you, Mr. Chairman, members of the committee. It's always good to be here in JPR until the very end. There's still one more bill after for me. So although we do appreciate the senator's introduction of the bill, ADL has long been, for the record, sorry, Meredith Weisel with ADL, the Anti-Defamation League. And we are in opposition to Senate Bill 609. ADL is a leading anti-hate organization. We train over 14,000 law enforcement on a yearly basis, specifically on hate crimes, bias, extremism, and terrorism each year. What is important to remember is hate crime laws were set up specifically
for a personal characteristic. So a profession is not considered a personal characteristic. You are talking about things that are usually considered immutable. Race, ethnicity, religion, specifically related to that. ADL actually helped draft the model hate crime law that is used throughout most states right now back in 1981. And we are definitely seeing a trend, to answer the senator's question about these types of bills coming up. Most are not passing them. There have been a few. I do not have them off the top of my head. Part of it is because Maryland law, just like many other states, actually covers this already. If you look at the criminal code, it's section 3203. It specifically actually takes an attack, an assault against law enforcement and first responders. And I think it says parole officers in there as well, as actually felony, not as a misdemeanor. It already takes it more seriously than an assault on a civilian. And this would actually dilute the hate crime laws, which again are very specific to a personal characteristic, something that most of the time somebody cannot change. It is not specific to somebody's profession. And although we do appreciate this, and I think it's important to take a look at the laws and how, because we are seeing an increase on assaults against law enforcement, this is not the right avenue to do it through the hate crime statute. So for these reasons, we ask for an unfavorable report. Thank you.
All right, Ms. Levy, we're ready for you.
Thank
Welcome
you very
back.
much. Thank you. This is Debbie Levy from the Office of the Public Defender. We also urge an unfavorable report for Senate Bill 609, echoing many of the comments that the prior testimony you just heard. Maryland hate crimes law primarily models federal hate crime law. In October 2009, Congress passed the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act. That law expanded the 1969 United States federal hate crime law, which previously addressed crimes related to people for their race, their color, their religion, their national origin, and now also includes folks' perceived gender, their sexual orientation, their gender identity, or their disability. Mr. Shepard and Mr. Byrd were both brutally murdered for immutable characteristics for their sexual orientation or their race by folks who either had phobias towards people who were gay or had been admitted white supremacists. And so Congress responded by expanding that law, and Maryland follows suit. And like the Anti-Defamation League stated just a minute ago, a person's chosen profession is not an immutable characteristic, but also more importantly, folks who are vulnerable, people who are protected by hate crimes law, have shown a history of discrimination and a history of abuse in our country. And a chosen profession, particularly a person who's in a professional space of power, is not an individual who was designed to be protected by the hate crimes law. There are enhancements that this body could enact for crimes. Of course, the Office of the Public Defender doesn't advocate for enhancements, but there are enhancements in our state law already, and there are many enhancements in federal law for directing crimes toward law enforcement officers. And it is somewhat of a sort of perversion of the reason these laws were designed to protect vulnerable people. And we hope that this body can see that. And if there is a need to target other specific crimes, to find another way to do it that keeps intact the policy considerations.
Thank you very much, Ms. Levy. We'll hear from Senator James.
Thank you, Mr. Chairman. I hear this issue about immutable qualities, but I'm not sure that protecting people religious beliefs falls under that category, nor do I think Maryland's recent addition of homelessness fall under that category. So let me just preface by saying I've never been very supportive of the concept of hate crimes, because I do think that I think crime is terrible. And I think it's very hard to start differentiating about who's more deserving or less deserving. But I would note to both of the opponents that I did a little research, and visiting professors at Yale and Harvard have both advocated for the inclusion of law enforcement. One, because we've certainly expanded the law beyond immutable qualities, which is going to happen when you start creating laws like this to begin with. Professor Frederick Lawrence, when we punish certain things more than others, we recognize the greater harm that is caused. When we don't, we make a value-laden statement that it makes no difference. And both of these professors, which I welcome you all to look up, talk about more than anything else, these hate crimes are value laden decisions. And law enforcement very much falls into the same kind of groups in terms of that they mourn together. The impact on the community is huge, and it has a ripple effect. And so really hate crime laws are reflecting our values. So I know you all don't want to argue it's immutable qualities, but I think more than anything else, it's a value laden judgment. So if you want to respond, that's fine, but that's where we are, I think. And these professors are experts in this area, nationally recognized.
Yeah, look, so first of all, Senator, thank you for the question.
Sure.
And I totally appreciate it. And I think there are certainly differences of opinion, for any of us who are lawyers, I think a lot of us could argue, different ways. It's not just immutable. These are also what we consider personal characteristics. I will just say from ADL's perspective, we have not taken a position on homelessness for that particular reason, because the model hate crime laws did not actually advocate that. Maryland also, you brought up religious beliefs.
Did you come in and testify against it?
Huh?
Did you come in and testify against the addition of homelessness because it was?
We didn't take a position on it, correct? Yes.
All
We
right,
did
that's
not take
okay.
we did not, we did not take a position on it. And when it has been brought up in other areas of the country, we also have not taken a position on it. Where our position is very clear on some of the things I mentioned before, race, ethnicity, religion, which interestingly, that's what I wanted to bring up. There is a bill in the House right now because Maryland law, believe it or not, does not actually say religion. It only says religious beliefs, and the intent is supposed to be religion. So there is a bill actually that hopefully this committee will take up as soon as it gets out of the House to specifically mention religion, which is different than religious beliefs, which is what
both of them are not, they do not fall under immutable qualities.
I would disagree with that. I
Okay.
certainly appreciate your position, and I appreciate the positions of the professors that you named, but I think there is a better avenue to this. I don't disagree that law enforcement has definitely been targeted. I mean, we work directly with them on a regular basis related to this. I just think this place is not the right place for it. I think the current statute is a better avenue to look at that and to look at changing it, which also covers things like first responders, parole officers. I think the criminal statute is a better place under it, where I think it's 3203 is what I said. And that is a better avenue. This, by adding law enforcement, dilutes the way the current hate crime laws were set up. So I certainly appreciate it. I think agree to disagree on some of this.
I've given you wide latitude to
Yeah.
answer for a very long time. I recommend you read these national experts. Thank you, Mr. Chairman.
If I may just also briefly have an opportunity to respond, thank you for the question. I do just want to point out, as a Jewish woman, not just an employee of the Office of the Public Defender, that for the fabric of, in terms of whether something's immutable, my ancestors were killed in the Holocaust because they were born Jewish, regardless of what they believed. And there are lots of folks who believe that your Judaism or your race or your color is immutable because it's beyond your change. So I just want to make clear that that is an immutable characteristic in large measure for a lot of people. In addition to that, I do think, Senator, that you are correct that these are values-based decisions. And when Congress, which by the way, has been addressing a similar movement in Congress, which was rejected in 2018 and was presented again this year in front of Congress and has not at this moment in time passed through any chamber. And when Congress did pass the act in 2009, they said hate crimes are important because they provide protections where they didn't exist, because violent hate crimes pose a serious national problem that federal law had no manner to address, and that hate crimes threaten to ruin the very fabric of America. And so it is a values-based decision. You are correct on what we as a country and as a state have decided to protect. And I think that this body would share the values that folks who are vulnerable, folks who have been discriminated against, folks who have been physically abused and verbally abused are folks who are worthy of the protection.
I've given you a long time too. And first of all, in no way was impugning Judaism or the fact that it is one of the few religions where the intersection of ancestry and religion are deeply entwined. But since the law doesn't focus on Judaism, but all religions, that's where the argument of it not being immutable comes in. And just additionally, I just think, again, we'll have to disagree on the value of, but law enforcement are vulnerable. They go out every day and risk their lives. Many of them die in the line of duty. So I do think that's an extremely vulnerable class of people that we ask to die for us. So I beg to differ on that particular last point that you made, but thank you.
All right. Thank you very much. With that, that'll conclude the hearing for Senate Bill 609. We'll now move on to the last chapter of the Folden Legislative Day, Senate Bill 610.
Yeah, I will. Yes, ma'am. All right, we're closing this down strong. This is my last one for the day. Hello. Mr. Chairman, Mr. Vice Chair, esteemed colleagues, for the record, William Folden, Senator for Legislative District 4, Frederick County. The bill I have before you and my final bill of the day, thank you, is Senate Bill 610. Senate Bill 610 deals with the intercept of wire, oral, or electronic communications, except the exception for imminent danger. And in short, what this bill does is it allows, so Maryland has a two-party consent law for any type of instances where there is recording occurring of audible occurrences. What this bill would do is for those who are in immediate imminent danger of the prescribed crime, a crime of violence under the criminal law article, stalking under the criminal law article, abuse under the family article, or a violation of a protective order that is also tagged with the stalking issues that we're seeing for our citizens, that in those certain and only those certain set of circumstances that the two-party consent rule would be disallowed, would not be required. Because in those moments, they are very vulnerable, they are at risk, and they are at risk of severe, potential serious bodily injury or even up to death. In those moments, we need to make sure we're doing our part to prescribe to the idea that our victims need to be able to have the tools to show law enforcement or the survivors, unfortunately, in some of these cases, what they had gone through, and that it is not acceptable. And we need to stand unified on this front to protect these victims from these perpetrators who assault and prey and stalk on our citizens. And let's be honest, a lot of these victims are ladies, are females, and we can't continue to have certain classes of our group, of our citizens, being vulnerable, unable to protect themselves without having the tools to show in a court of law or show law enforcement what is occurring and the volatility of what they're being subjected to. And with that, I will close and ask for your support of Senate Bill 610, and I will turn it over to my panel. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. I'm Carrie Tyrrell, Supervising Attorney at the Maryland Coalition Against Sexual Assault. I am here at the invitation of our director, Lisa Jordan. MCASA is the coalition of the rape crisis centers across the state of Maryland, and our office includes the Sexual Assault Legal Institute, where we provide direct representation to survivors of sexual assault and abuse in Maryland. We are here in support of Senate Bill 610. Like all of my colleagues, I have many stories of recordings survivors made as acts of abuse were being committed against them. Recordings that can't be admitted in Maryland courts. A 14-year-old survivor was in a car with a driver her parents had hired to pick her up from sports practice. The driver began making very suggestive comments. The survivor became frightened and began audio recording him in the dark without his knowledge. The recording not only captures the directly sexual propositions he's made, but also the sounds of the perpetrator sucking on that teenager's skin. That recording, under Maryland law, is inadmissible. This has been going on for a long time. Our colleague Scott Schellenberger shared that in the early 1990s, he had a case involving a young child who had a plug and play toy. The child hit record and taped what was very clearly a sexual assault, but
The wiretap law prohibited this excellent evidence from being introduced. At MCASA, we know of at least 3 cases where a rape, not an apology, but the actual rape, was recorded and the jury cannot hear the evidence. Every time we talk about this bill, we hear more stories of victims who taped crimes and victims' children who taped crimes. Not only are these recordings inadmissible under the current law, we attorneys are forced to advise any survivors who knowingly made a recording that that recording itself was a crime. MCASA fully supports Senate Bill 610 as written. We recognize, however, this committee may wish to take a smaller step, perhaps permitting only taping of serious crimes, and we urge you to do at least that.
Good afternoon, Mr. Chairman, members of the Judicial Proceedings Committee. Again, I'm Sarah David. I'm Deputy State Prosecutor of the Maryland Office of the State Prosecutor, but also here in the capacity of being a member of the Maryland States Attorneys Association, who also supports this bill. This would legalize recording somebody without their consent if the person recording had a good faith fear that they were a victim of a crime. So I want to talk about that because that's a change from last year's bill, and there are 2 that I want to highlight. The first is that this language, rather than a reasonable fear, allows for a clearer standard so that the person is able to, or the witness is able to articulate their basis for recording at the time it was recorded. So the question shifts from like, what would a reasonable person do in this circumstance can be a confusing standard, to why did this person have a good faith basis that they were a victim of a crime in assessing the recording? And so that's clearer for courts. The former legislation also included evidentiary standards that would make this type of evidence different from normal evidence. This now legalizes the recording. So if I am in a position where I am a victim who is afraid that someone is committing a crime against me and I start recording, it's legal. So now we're in general hearsay evidentiary territory for those of you who were not traumatized by the bar exam. What that means is out-of-court statements that are being offered for the truth in court have all of these different evidentiary rules that surround them, and they would be standardized in this process. I'm happy to take any questions, but we do urge a favorable report. This would be very important to use in evidence of these types of crimes. Thank you.
Excellent. A couple questions from Senator Sidnor and then Senator West.
They're probably gonna want you all.
Thank you. If I could speak to Ms. David.
Absolutely. Come right on up.
Couple questions. I think probably outside of Linda Tripp, the most prominent prosecution of someone who violated this wiretap law, I think just happened a couple of years ago with the young man who was in Congressman Harris's office. My question is this: how often are people do you know how often people are actually prosecuted for the violation of these wiretap laws?
So that depends on sort of the context of it and kind of the intent of the statute. So our office handled that prosecution, and I'm not going to comment on sort of the nuances of that case or when there's sort of an intentionality. Mm-hmm. The bigger issue here is not necessarily that people are prosecuted for it. It's that the evidence is not admissible for any reason, right. Not for impeachment, not for anything. Right. And also by allowing it to be legalized, then we're not dealing with an immunity issue. Because we can't always control, when someone is or isn't going to be prosecuted, because we have the ability, as you know, in Maryland, citizens can go and take out charges with a commissioner and other things. So how many times do prosecutors do that? I don't have those numbers, but it is kind of a prohibition on the evidence coming in, and then thus is a deterrent for that evidence coming into court.
So then the next question that I had is, what happens to the people who this bill is intended to protect when they have recorded something? I'm assuming, although technically the law was broken, I'm assuming you all would not press charges against those people, right?
So Senator, great question, because that's an important clarification here that I want to highlight again. It would not be a crime anymore. So I
got this.
Yep.
I'm trying to understand circumstances as we are currently
Yeah,
experience
you're
and
saying that if
law.
somebody came in and said, I had a good faith basis for this, would they be, they wouldn't have committed a crime then? Do you see what I'm saying? So they couldn't be prosecuted.
Under the current law?
No, under current law, yeah, okay. So under current law, would the person be prosecuted? I would say that certainly it's not somebody that I personally would prosecute.
But they would be in legal jeopardy.
They would be in legal jeopardy of it, and certainly an attorney in a family law situation or any other type of situation would want to advise them of that.
Gotcha.
And so that's under current law, but under this law,
Right,
it
under
would
this-
be legal.
Right, you said you put it essentially, it's then hearsay, it's legal, you're able to then
Yep.
possibly use it if it's one of these listed crimes.
Yeah.
Can I just comment real quick, Senator, on that?
You don't have to,
Well, I just want to be clear that intent is an important element of the crime. And a lot of people right now don't understand that they're looking at it that through the idea that they're trying to protect themselves.
Right.
And they're hitting record. Their intent is not to be malicious or use it for unscrupulous reasons.
Right,
They're literally trying to protect
It's
themselves.
evidence.
So in that manner, they're not going to do that. So understanding that that intent is really 9/10 the law. Like
Yeah.
there's got to be that intent there.
No, I get it.
Yeah,
Thank you.
Thank you.
Thank you, Mr. Chair. So I feel like this is deja vu all over again. Early in this session, Senator Sidner had a bill to. So Senator Sidner had a bill to permit people who were trying to catch fair housing violations to do, I think the words were exactly the same in his bill as in this bill, to intercept a wire, oral, or electronic communication. And he and I had a lengthy colloquy, and he subsequently agreed to amend his bill. And I think we've solved our problems. So, but I've got, I guess, the same problem with this bill that I had with his bill way back when, which is that Maryland currently has a two-party consent rule. So if I'm talking to you and I can't wear a wire inside my pocket because you don't know what I'm doing and you haven't consented. However, since it's two-party consent, if you tell me something which I'm worried about, I could go see the U.S. attorney or the state's attorney and I could report you. I wouldn't have a wire so that I couldn't confirm that you said it, but I could have the state's attorney, the U.S. attorney start to look into you. That's permissible under Maryland law, right?
Well, I want to actually divide that. That's not permissible under Maryland law because that'd be a distribution of an illegal wiretap. And
No. Let's assume I'm not wearing.
Oh, just that you said this is the conversation I have.
If you tell me incriminating things, you know I'm listening. You know you have no control over me. And if I go see the U.S. attorney, you have no reason to complain. Well, you might not like what I've done, but there's no legal complaint about what I've done.
I will also note that there is one party consent federally, but yes, I understand where you're going. Yes, there's no legal complaint about that.
Exactly. So, however, I have no problem in this bill or with Senator Sidner's bill with authorizing one-party consent in that kind of a situation where it's you and I talking. Right now, it's prohibited for me to have to have a hidden wire. But with one-party consent, I can consent and have legal tape and tape record what you're telling me if there's a concern that there's an imminent danger, that I'm in imminent danger of becoming a victim. Got it? What I don't understand on this, which I didn't understand 6 weeks ago when Senator Sidner brought the bill, is this includes wire or electronic communication. So what this bill tells me is that if I want to, I could wiretap your phone. And I could intercept conversations you're having with other people. That I believe is a violation of the Fourth Amendment. Because normally in order to wiretap someone's phone, I have to go to court and I have to show to a court, convince a court that there's probable cause to believe you're involved in a crime and get a court to authorize me to wiretap your phone. It appears to me this bill authorizes me to wiretap your phone without going to a court, which I believe is a Fourth Amendment violation. How do you respond to that?
I think that that's actually an interesting expansion of sort of where kind of the wiretap law evolved from and where it is now. Because of the way that this is written, because it says the person has to be in imminent danger, I don't think it would authorize then a third party to come in and, so it's not going to authorize the person has to be in imminent danger based on the way this is drafted. So a law enforcement agency can't come in and then do the recording. So that's the distinction. So this wouldn't authorize what you're describing. However, of course, the criminality existing, right? The wiretap criminality existing at the 5-year felony and the exclusionary evidence state that it does is to deter law enforcement from doing that, is to deter the police from coming in and committing that violation that you're describing. So this is not drafted that way. However, because of the good faith basis of the person who is doing the recording, if it were a wider swath and not drafted this way, I think that we could have a discussion on the challenge, like that would introduce a different issue.
Well, let me pursue this a little bit. So as I did with Senator Sidner several weeks ago, and we finally reached a meeting of the minds on this thing. So this is a statute that we would be passing. So it would be state action to authorize me to wiretap you without going through the courts. And then presumably, once I got the results of the wiretap, I would take them to the state's attorney. And the state's attorney would then indict the person who is planning to subject me to imminent danger and try to use the wiretaps that I have gotten to prosecute that person.
No, that's not how it would work, because the statute is written that the person who is recording has to have a good faith basis that that person is in a position of imminent threat.
Right.
So no,
I think I'm in imminent danger.
Okay.
And you're gonna somehow subject me to violence. So I somehow wiretap your phone in order to catch you making incriminating statements about how you're going to attack me and hurt me.
That's not how this bill is drafted, because it says to record an imminent, the person has to be in imminent, it's good faith belief that the person is going to become in danger of becoming a victim of this, not that another person.
No, it's me. I think that you're going to do bodily harm to me.
Okay.
So in order to get the goods on you, I am now going to put a tap on your phone and catch you making incriminating statements on the phone about how you're going to hurt me.
Senator, this is imminent. This example you're giving is not imminent. In law enforcement, that when we're out there, imminent is right away. There is an immediate threat to your well-being and safety.
Well, that being the case, why do you want in the bill to authorize me to place a wire or intercept electronic communications? It sounds like a wiretap on your phone.
So you're looking at that because that's the prescribed language that's under the article.
Precisely, and Senator Sidner and I have agreed to take that language out of his bill. And my question is, why won't you take that language out of this bill?
You're getting stuck on prescribed language under a specific section of the law.
Right.
And you're missing the bigger point of this, which is you can't do a wiretap for the immediacy of an assault that is about to occur to you. That wouldn't fit into this definition. Okay. So it still fits as worded. It just says that the threat, the immediate danger is what would allow the person having good faith belief that they were in immediate harm's way. So the example you gave with the state prosecutor doesn't apply. It's not immediate. Immediate is if I'm walking towards you right now and you're worried that I'm going to assault you, you hit your phone and record it because you're in immediate fear for your well-being. And then if something happens, you have something to give to law enforcement to say, look, this is what happened. That's all this is.
Okay, let's bring this conversation to an end.
Please.
I'm gonna provide you with the same solution that Senator Sidner and I agreed to, and see whether or not you think it works.
The difference between Senator Sidner's bill and this one is Senator Sidner's bill is a setup design that would allow them to go in and have this dialogue with the fair housing. This is an immediate threat to the person. There's no immediacy in Senator Charles's bill. It's happening. It's going in. They're doing that. This is an immediate bodily injury, risk of bodily injury or harm.
And just to finish up, I fully agree with you that under such circumstances, the law should permit you to turn your phone on. That's one party consent. It's between you and me, and you're recording what I'm doing. And I'm totally with you on that. Where I'm not with you is thinking that you're in imminent danger from me and then going back and putting a wire on my telephone.
I understand. I'm not asking you to co-sponsor the bill, though.
No, okay, thank
So,
you.
It's written.
First off, I'll apologize to Senator Kagan. I thought this was going to be not a pitbull, but a little bit clear. So we called you in. Welcome to this
Sorry,
enlightening
Senator.
discussion here. We'll go with Senator James and then Senator Cinder. I will point out though, that some of the drafting is a little, I know what's being expressed here is one thing, but the drafting seems to kind of push us in another direction. So it's unlawful for under the subtitle of a person to intercept wire or oral or electronic communication if the person has good faith belief that the person intercepting the communication or another person is in imminent danger of becoming a victim. And then it says for the 14101 crimes, the crimes of violence, but then stalking. And then I'm like, okay, so what's the definition of stalking? And then stalking, the definition is a course of conduct, which is not immediate. And so there are some things that seem to be in contravention of this immediate language and intent. And also, is it the person or also another subject that you're recording for? So there are a couple things that in terms of drafting that I think are tripping up the senator from Baltimore County. I don't think it's, the drafting is something you can work on. Senator James.
That was one of the things I was gonna bring up is that problem with the person or the person who believes they're in imminent danger, which may not be what you meant, but it certainly is confusing. And the only thing I could think of is if the person who's about to assault you is here, but somehow you got on the phone with somebody else who's telling you about it. But in any event, that's far-fetched. I just want to also applaud your panel for really compelling and not leaving this to the abstract, but making it very real for me. I don't want to get too sidetracked. I am curious as to what the opposition would be, and so I would be curious about that. And then to tell you that I had a bill earlier that deals with a hearsay exception, and the way they protect the defendant's rights is you do have this sort of separate. You stop everything. You have the separate evidentiary hearing about whether the conduct meets the exception to this admission. It's somebody who's intimidating someone not to show up in court. I know the state's prosecutors are very familiar with it. So I bring this up only because I don't know at what point in the system does the person who wishes to offer this into evidence do you have an evidentiary hearing to make sure that the good faith where would this land? And the reason I bring it up is in case there's some opposition about compromising defendants' rights and due process and confrontation or whatever it is. There are mechanisms to do it, but how would this get into evidence? When do you establish the good faith imminent danger situation?
So we have a process in sort of the criminal, well, in all court systems, which are motions in limine or motions to suppress or things like that. So we can.
So that's when you.
Yes. So this would be provided in discovery, up to defense counsel, and then they would have the opportunity to challenge sort of that in different types of motions.
So even if we make this lawful.
Yes.
The defendant will still have the opportunity to argue, there wasn't, whatever he wants to argue, but every other, it wasn't imminent, or I didn't cause the damage, or whatever they want to do to challenge this other than its legality.
The evidence that comes into court that are out of court statements for the truth are in every trial. I mean, sure, they are very, 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 very
common. And then there's about another dozen that are technically not hearsay, but
it happens all the time.
Yeah.
And so that's a very routine part of sort of trial practice and evidentiary.
And I don't see an opposition in my documents, but just if there are, I want you all to respond to them in writing to me because I'm very supportive of this bill.
Okay.
Very supportive.
Of course.
So on page 2, line 14, if we were to delete the term intercept a wire, oral or electronic communication and just say something along the lines of it is lawful under the subtitle for a person to record the communication, would that still get you where you're trying to go?
I think that there's ways we can, I don't want to commit to language for kind of a wider group, but I think that there, and certainly not for the sponsor, I think that there's ways to get to this language. I'm also thinking about your question, Senator West, and there, I think most of these crimes we actually could get a wire under, which is a separate issue. So I'm thinking sort of about that too, that we would want to make sure that the language is that there's an application for a wiretap that most crimes of violence do fall under. Exactly. And so I think that we want to make sure that this isn't also interfering with the ability to do that. So I think that that's an important point. And yes, Senator Sidnora, we can play with the language to make sure that it's precise.
Thank you.
All right. See no further questions. Thank you all very much. Is that it? We have is Ms. Shapiro here? Okay, she's not. Okay.
Yeah.
Got it. Thank you very much.
It was 2-2.
Oh, sorry. Well, she was favorable with amendment, so.
I believe the amendment, if I may, because.
Sure, of course, yeah.
She had suggested adding assault or changing the crime of violence to public safety, but actually, if you look at the definition of abuse, the definition of abuse already covers assault too. So I think that. Yeah, and I was concerned about it as well, but I actually just reviewed the law, and abuse itself is only about the crime, not about the relationship. So assault 2 would already be covered as drafted. Certainly from MCASA's point of view, I think that the issues raised by our censorial senators could be addressed.
All right. All right, with that, that'll end the hearing for Senate Bill 610. We'll now go on to Senator Kagan with Senate Bill 650. Welcome.
Good to be here. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. And I am hoping that this one is a quick and easy way for you to end your day. I believe I'm best for last here, or close. Oh, okay. All right. Almost. Unfortunately, we all know that hate and violence has been skyrocketing in the last couple of years, whether that's anti-Semitism, racism, homophobia, transphobia, Islamophobia, anti-Asian violence. It's everywhere. And I know this committee has been very focused on trying to figure out different solutions. This is a niche, this is a small piece, which is when there are symbols that are put on public property or private property. It's just making sure they get removed in a timely manner. So there's a swastika, there's a noose, there's something that's put up here. And sadly, my colleague and our colleague, Delegate Joe Vogel, had 4 swastikas in his building, in his apartment building. And he notified management. And they said, oh my gosh, that's a problem. And they did nothing about it. And he notified management and that's a problem. And they did nothing about it. And it took days. It should not take days. So this bill simply says within 24 hours, after the police have been notified, the property owner is going to be notified, and the offending item, which causes fear and vulnerability, has to be removed. It does not apply to private property. If you decide you want to fly the Confederate flag on your own house, I don't have to like it, but it's your house. It's not offending you. You're not a victim. It stays up. But you get one warning. And then if it's a problem, if it's still up there after 24 hours, there would be up to a $1,000 fine. That's the bill. I'm happy to take any questions. And I'm delighted. You didn't call my witnesses, sorry. Lisa Jordan just left, but Meredith Weisel.
I can speak for everybody.
Okay, with the Anti-Defamation League and Meredith Weisel and Deb Miller with the Jewish Community Relations Council. So pretty simple, and we think it's a reasonable solution to a problem that does need to be acknowledged and addressed. So with that, thank you, colleagues. Thank you, Mr. Chair.
Thank you, Mr. Chairman, members of the committee. For the record, Meredith Weisel with the Anti-Defamation League. I will tell you also the Jewish Community Relations Council and the Baltimore Jewish Council also all submitted testimony. There's an advocacy day going on, so everybody is running around. So you have me for everybody. What I will tell you is this is something that we are continuing to see throughout various communities. Vandalism is one of the highest forms of hate that we are seeing. Assaults are certainly, there's an uptick, harassment is an uptick, but vandalism has some of the highest numbers. This bill is a way to solve that problem, or at least to address some of it. And if you look in my written testimony, what I want to just highlight real quick is the Maryland Hate and Bias Report that comes out every year from the Maryland Police and the Maryland Coordination and Analysis Center. The past 2 years has showed some of the highest numbers that they've seen. It's also the highest amount when we're talking about hate bias incidents is in vandalism. So in 2021, the numbers was 27.7% of incidents, and in 2022, it went up to 29.6%. This is consistent with the data that ADL is also tracking. We specifically track a lot of hate and bias, but we put out an audit every year of anti-Semitic incidents, and the numbers we are seeing of vandalism have continued to increase. The numbers we are expecting to release for 2023, which will be coming out in the next month or so, are going to be even higher. And in Maryland in 2022, the data, again, I just want to point you to my written testimony, ADL documented 109 anti-Semitic incidents in Maryland. 43 of that was vandalism related. And so you can just see the numbers that we're talking about, and specifically what Delegate Vogel, what Senator Kagan gave the example of. It actually took ADL intervening as well and sending a letter on his behalf. So this is a state delegate who lives in an apartment complex, and we do this, it doesn't matter who you are. We had to intervene, contact management for the third time to finally get them to remove the graffiti. So we would ask for a favorable report. Thank you.
All right, Senator, thank you. Questions from the committee? Seeing none, thank you all very much. Excellent.
Thank you all.
All right, and with that, that'll conclude the hearing for Senate Bill 610. We'll now move on to our final bill of the day, Senate Bill 404. We passed this bill, I think 3 opposition. We passed the contents of 99% of the contents of the bill with, I think, 3 people voting opposed. So I'm going to give you the background, introduce the bill, and then I think it's very important. Is Mr. Morris here? Yes, you can take the podium. I'm going to introduce the bill, but I think it's important to spend the balance of most of our time hearing from you, because I think you have compelling testimony to provide. So obviously in 2022, we made the decision to legalize recreational cannabis, and we also have subsequently laid out a licensing regime for not only the medical, but also the recreational, and that's still in process, but that's become the legal regime for us here in Maryland. So a lot of the mandatory minimums with regard to volume dealers, not only of things like cocaine, but also for cannabis, those laws should be revisited, and we should start thinking about how we can lift the mandatory minimums for the kingpin and bump up, yes, the sentencing to 20 to 40 years, but get rid of those mandatory minimums so that there's more latitude, especially given where we've taken the policy direction that we've taken here in Maryland. This bill also encompasses several new offenses for firearms and trafficking. So it addresses ghost guns, augmenting the frame or the receiver by etching off the serial numbers, creating the ghost guns, possession of ghost guns. And so it has some enhanced penalties for that. It turns the theft of a firearm into a felony from a misdemeanor in this as well. I know we have several vehicles in the committee to do that. So essentially the bill, apart from the gun offenses, is broken down into 3 buckets, 2 other buckets, cocaine and cannabis. And for cannabis, it adjusts the charge for cannabis kingpin volume dealer, and it eliminates that mandatory minimum, as I discussed. It also bumps it up to a 40-year maximum. It creates a look back feature for those currently incarcerated for cannabis and that kingpin volume dealing to have their sentences reevaluated under certain circumstances. It also authorizes a person that is at least 21 to manufacture that personal use amount for cannabis, things like the brownies and the like. And for cocaine, it offers a look back for release. It creates that feature for kingpin and volume crack dealing under similar circumstances as I described for cannabis. This is a discussion that we had during justice reinvestment. There just wasn't the political space to have an honest and earnest discussion over that. And then the guns that I outlined, I won't go into detail with that again, but I want to yield my time to hear from Mr. Morris, who has, I know you were at the House hearing and you were here last year, I think, as well. So
Yes, sir.
Mr. Morris, I want to yield the floor to you so you can lend your personal perspective and then I can take questions.
Thank you, Mr. Chairman and committee, for listening to me. The Senate Bill 404 is a major step forward to reform rather than unnecessary punishment. This bill ends 40-year sentencing with a mandatory minimum sentencing of 20 years without parole for nonviolent marijuana offenses. To give an individual 40 years in prison with a mandatory minimum of 20 years without parole for anything nonviolent is draconian. This bill still has effective sentencing of up to 20 years for nonviolent marijuana distribution, which is enough. If passed, judges will have the ability to sentence individuals accordingly to their crime, whether it was violent or nonviolent. If not passed, sentencing will remain a one-size-fits-all mandatory minimum, classifying nonviolent with violent as one. My son, Harold J. Morris III, was sentenced to 20 years without parole for a nonviolent marijuana offense. He has been sent to prison in a population of mostly violent criminals, being classified and determined by time. Classification is determined by time, not the nature of the crime. My son waited 2 years for trial and didn't count on getting 20 years sentence without parole. From day one, he had served God and taken his family to church every Sunday and prayed that he would be able to remain with his family. Being said, the thought of 5 to 10 years was enough to reform someone. I have thousands of signatures from people online and person who believe that no one should do 20 years in prison for a nonviolent marijuana offense. Through my years of advocacy, I am convinced that the majority of people agree with this bill. To oppose this bill, you would only keep nonviolent marijuana offenders in a cage to serve just as much time as violent criminals and remain classified as such, and to be re-entered in society, institutionalized, as my son would be in his 50s and his children in his 30s when he's released. So I'm asking for a favorable report for Senate Bill 404. Thank you.
Excellent. Thank you, Mr. Morris, for your continued advocacy. It's good to see you again. I'll chat with you when yeah. If you hang out for a second, I'll come out when we're done here. All right, seeing no questions from the committee, that'll conclude our hearings for the day. Tomorrow's just a normal day, so we don't. Friday voting, we're looking at Friday at 9:30. Is that cool with everyone? We've gone over the voting list, and I think we should be. We're going to continue going over the voting list and a couple other bills, but I think we should be in good shape. We are. No, are we? No, we are not. My apologies. We are not. So no bill hearings, voting session. We should be done, God willing, by 11.
There is no floor.
There is no floor. It's pro forma on Friday. Yeah. So if we do 9:30 to 11, I think we should. That means we're going to be here till 3. But that, you know. All right, we're out.